Michael, did you want to start us off?
Perfect.
Thank you.
Welcome committee members, liaisons, and members of the public to the Council on Access and Fairness meeting. Thank you for joining us. We are using Zoom with the goal to foster a more inclusive environment and an effective meeting. If you'd like to comment during the meeting, please use the raise hand feature. Please utilize this tool to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. A friendly reminder that this is a video conference and to please be aware of your surroundings behind you. All LSTFC, and committee meetings will be recorded and posted to the State Bar website. Zoom captioning is available. To enable, select live transcript at the bottom of your Zoom screen, and then select enable auto transcription.
Thanks, Michael. Good morning, everyone. Welcome to the quarterly meeting for the State Bar's Council on Access and Fairness. We are so grateful you are all here. Before we begin, Elizabeth, could we take roll to establish a quorum?
Sure. Anderson? Coleman?
Here.
Harrison?
Here.
Rhodes?
Here.
Richards?
Here.
Salceda? Santoro? Torres? Rosie?
Here.
I want to acknowledge Sarah Good, our board liaison, as well as staff. We have Shannon, Michael, myself, I'm Elizabeth, and Kim. And then we also have our liaison. So we have Judge Dulcich so far, as I see on the screen. And then we invited our newly appointed COAF members. Their terms don't start until September, but we thought this would be a nice opportunity for our COAF members, current COAF members, to meet them in advance of our December meeting. So I think we're trying to promote all of the incoming members, so we can see you and do some introductions.
Yep, we'll do that in just 1 second. And I see at least 3 of our incoming members on the screen. Okay, so at this point in our agenda is the time when we take public comment. As many of you know, the State Bar encourages written public comment prior to the meeting, and we do allow public comment during the meeting. We received public comment that's related to the state to the bar exam testing accommodations and the process for accepting written public comment. Those items are not on our agenda for today's COAF meeting, and they're not within our purview. However, those comments have been shared with members of the Committee of Bar Examiners and the staff of the Office of Admissions. And I believe COAF also saw those public comments as well. If we have members of the public who wish to make a comment, I'm going to call on you in just 1 second. A reminder that we limit public comment to 3 minutes per person, and Shannon will help us with the timer if necessary. Given that I cannot see who's not elevated, is there any member of the public that wishes to make public comment at this time?
Yes, there are 3 hands raised.
Thank you, Shannon.
I'm going to allow the first person to speak.
Hi, thank you. I don't see a timer yet. But anyways, my name is Ray Hayden, and I have a proposal for the alternative to the California bar exam. My proposal could be up and running by February 2024, and certainly by July 2024. My program assures greater protection for the general public, assures greater competence of newly licensed lawyers, and rock-solid guarantees a more diverse and balanced California bar membership. The program will not only save CalBar millions of dollars instantly, it will also allow CalBar to lower fees currently charged while actually bringing in more funds to support CalBar programs, which may be underfunded, creating a balanced budget. The program is offered remotely over a 12-week period, 8 weeks to complete the main program, and 4 weeks to make up anything not completed successfully during the 8 weeks. The 12 weeks is based on the period of taking a February exam and waiting for the results. Law schools don't need to change anything. but they are certainly allowed to tweak their programs to be better. This program includes learning materials, quizzes, and an exam for each subject to be covered. By the way, no subject that would be required for a newly licensed lawyer would be omitted. Everything would be included. The focus is not on law school, but on becoming a successful newly licensed lawyer. In fact, the study of law and prep for the bar exam completely fail to prepare someone to be a newly licensed lawyer. My program fixes that. I urge CalBar to invest about a week considering my proposal. I charge nothing for this. I don't need money. I give this program away for free. It's been in use with emergency services personnel nationwide for about 20 years. It works. The simplicity of the program is what makes it work. You have my contact information, and I suggest you make use of it and learn more about this program in detail. And I thank you very much for your time. Have a wonderful meeting.
Thank you.
Thank you. I'm allowing the next person to speak.
Good morning, all. Thank you for the time. Actually, I have two things to say. My name's Todd, and I just want to talk about, as I always do, the 3-minute timer in the context of the Sunshine Act of 2004. So Article 1, Section 3 guarantees the public the right to instruct their elected officials, which implicitly infers the right to instruct their delegates or delegates. And so from the perspective of the function of the bar, and I'll go to another section of the Business and Professions Code, section 6001.1, protection of the public is the highest priority, no matter the conflict of interest. I'll repeat it. Protection of the public is the highest priority, no matter the conflict of interest. And then compare that to Article 1, Section 3 of the state constitution, guaranteeing the public's right to access. And given the nature of my well-known complaints to the bar at this stage, which we'll talk about in just a moment, it completely seems inappropriate that I be timed in a forum where you have several hours dedicated and only a few speakers. The bar continues to treat public comment as simply a designation of origin. For when the public comment is submitted, there's no place for me to go and retrieve the public comment. This, of course, is secondary to what I was really talking about, but the point is here, I've received copies of my public comment back in letters responding to my comments that have been redacted. My public comment has been redacted. Now, either that's suppression or someone has claimed an alternative privilege. Either way, I would be obliged to receive notice to know that my rights had not actually been directly violated. But here the bar does not do those basic fundamental procedures. Now I've exhausted my time talking about this thing that is so important, public access. But I'm really here to talk about the notion that the bar continues to propagate and promulgate policies that lead to disparate impact and does so intentionally. It is understood that disparate impact generally is discovered sort of after the fact. Oh, this policy has been in place and the people who've been sort of following it just sort of blindly along. Well, okay, they get a free ride.
Excuse me, time is up.
I understand that. I've invoked Article 1, Section 3.
So,
You're not
Todd,
respecting that.
Todd, I'm gonna give you, 1 more minute to finish that thought, okay? And then we need
Thank
to
you
move
very
on to
much.
the
I
next
appreciate
one.
that.
Thank
I
you.
appreciate the courtesy. Let me go to my main point. I matriculated to school, People's College of Law, in the fall of 2019. As of today, I do not have a degree. I do not have viable transcripts, and I do not have a viable course forward that will not cost me 2 or 3 additional years of study, although I've completed the entirety of the program at PCL. I've completed the entirety, all the courses they would offer. They refused to offer a fourth year. They informed the bar of their intended repudiation more than a year in advance. The bar did nothing but enforce against me a fourth year of study that I cannot obtain. I ask you to take that under substantive review and handle the issue forthwith. Thank you for my time.
Thank you.
And I'm allowing the last person to speak.
Hello, thank you. I'm Benjamin Cohn, and I wanted to respond first to the point that was made about the written comment and the purview of the body. Back in, I believe, February of this year, the testing accommodation rules revision was brought to you, and your advice was sought by the Office of Admissions. Since then, for today's meeting, there are agenda items about general topics on the future of the bar exam, as well as general catch-all topics about diversity, equity, and inclusion, which I think equal access to testing accommodations procedures and testing accommodation standards on the bar exam fall within, for the very loose purview about whether public comment is within the purview of a body. So I'm a little bit disturbed by that categorization of the comment that I submitted in writing. Now, there have been developments that I wanted to speak about since I wrote the written comment, specifically at the August 18 Committee of Bar Examiners meeting. At that meeting, the Committee of Bar Examiners advanced for another public comment period the rules revision proposal, and the latest version makes one minor change, but in substance rejects the overwhelming majority of the reforms requested by the disability rights community, which includes most civil rights and disability rights nonprofits, a lot of disability rights attorneys, myself included, and the California Access to Justice Commission, the members of Best Practices panel chosen by the California Department of Fair Employment and Housing and the Department of Justice for testing accommodations for the LSAT consent decree, a co-author of the Americans with Disabilities Act, and a number of other comments. There was an incident that caused some other comments to be suppressed due to IT failures or otherwise by the state bar. But the proposal that's been circulated is inadequate. It will not provide people with disabilities equal opportunity on the bar exam. And for that reason, I continue to urge that the council make comments during this newest public comment period urging further amendment, and that should the Committee of Bar Examiners refuse to do that, that it...
Excuse me, 3 minutes is up.
Mr. Cohn, go ahead and finish that thought and then.
Okay, but the last sentence was that should the Committee of Bar Examiners refuse to do that, this council take its purview to make a separate recommendation to the Board of Trustees that it do so instead. Thank you.
Thank you.
And we have one more hand raised. I'm allowing them to speak.
Action.
Hi, good morning. My name is Nat Brown. I'm wondering if someone could clarify from the council whether or not you guys will at least provide some sort of comment about what those steps are moving forward post the May 2023 report, what the bar is doing to look into further. I mean, beyond that report, and kind of, there were no real action items that I'm aware of that came from that. I'm wondering if someone could just clarify today if it will be an agenda topic, just again, broad strokes, what the bar is doing to move forward.
Ned, are you talking about the May report?
Correct.
I don't think that COAF is, I don't think COAF is gonna be making any comment on that. I can't speak for, the entirety of the state bar or any other state bar entity, or sub-entity, but I don't think that COAF, will be.
Okay, so no comment on that today, but will you guys, address what the bar's next steps are related to, outside of the public comment period, related to amending or potentially amending that bar exam?
Are we talking about the testing accommodations, or are we talking about the
Yes,
future?
I mean, related to testing accommodations or any aspect of the bar period at this point.
So what I can tell you is that the testing accommodations is not part of COAF's work plan. The items that COAF works on have to be authorized by the Board of Trustees first, and COAF's current work plan does not include an action item on testing accommodations. And so that's not something that is on our work plan to work on. We did receive an update from at one of the prior meetings about this issue, but it is not on our work plan, and so it's not something that we can work on. Does that help clarify?
Yeah, to some degree, I guess. Will the bar also be following up in any regard related to kind of action items that came out of its research and that was discussed in that May report?
Yeah.
Or now that the blue ribbon has been disbanded, is that just it?
I honestly don't know. That's not something that we've been briefed on. That might be something that the Board of Trustees could speak on at their next meeting, but that's not something that frankly I know the answer to. I apologize.
Okay. I appreciate it. Thank you.
Shannon, any other folks wishing to make public comment at this time?
No.
Thank you, everyone, for your public comment. COAF and the State Bar appreciate hearing from you all. Moving on to our next agenda item. We need to approve the minutes from our June 2nd meeting. The June 2nd, 2023 meeting minutes were distributed for comments and edits. Does anyone have comments or edits on our June 2nd, 2023 meeting minutes? Seeing none from what I can see, can I then have a motion to approve the meeting minutes?
I move to approve.
And a second?
I second.
Thank you.
I'll take the roll call vote.
Thank you.
Anderson, Coleman.
Approve.
Harrison,
Yes.
Rhodes,
Yes.
Richards,
Yes.
Salceda, Santoro, Torres, Rosie.
Yes. Did we hear Nova?
Novella, did you,
Yes.
okay, thank you.
Thanks, Novella. Okay, item number 4 on our agenda is the report from the chair. And that's me. For those who don't know me. So yeah, this is a bittersweet day for me. And we're waiting, I think, for Heather to get on. But today we say goodbye to 3 incredible members of our group, and I guess I can officially now also say goodbye to Sarah, because we didn't get a chance to say goodbye to Sarah either. For those who are incoming members, let me just tell you that 4 years on COAF goes by really in the blink of an eye, especially if it happens during a pandemic. And when Sal and Ryan and Heather and I joined COAF in September of 2019, we only got to see each other once before everything sort of shut down. And so we spent the last 3 years doing all the incredible work that we did virtually. And of course, as everyone on this council knows, none of that could have happened without the State Bar staff making it possible for us to get this work together and to do it virtually. And as we go through today's agenda, and I know we told the incoming members you only needed to be here for the first hour. You are welcome to stay for as long as you'd like. If you want to hear what we're working on and where your interests and talents might fit in with our action items. But as we go through today's agenda, I want to point out the things that Ryan and Sal and Heather worked on and were passionate about, because what you'll notice as we go through today's agenda is that these were all things that came from the minds and the hearts of COAF members. The agenda items are very personal, and the amazing work that COAF has done is because of the folks who are here right now, and especially some of those folks who are leaving us today, and Sarah, who left us a few months ago. So I want to have the current COAF members introduce themselves first, and then I will give the new incoming members a chance to introduce themselves. And so as we go through current COAF folks, your name, your preferred pronouns, your employer, and then our something fun question for today is, in the movie of your life, who would play you? So incoming members have a chance to think about that for a few minutes as the rest of us go through. But for those who I don't know, and I think everyone at this point probably has already met me, but I am Judge Kristen Rosie. I'm the Chief Judge of the California Department of Insurance, and I am the current chair of the Council on Access and Fairness, and I will, it turns out, be the chair one more year. So I will be sticking around 1 year longer than I was invited to. I understand that I will have to leave next year, even if I don't want to. I can't stay here. But I have been on COAF now for 4 years, and I will be doing my 5th year, and I think I've met everyone. Judge Michael, would you like to go next?
No, because we didn't hear who would play.
Oh,
you
you're
in
right.
the story of your
You're
life.
right. You're right. Thank you. And I didn't say my pronouns. She, her pronouns. I work for the California Department of Insurance. I'm also the president of the International Association of LGBTQ plus judges. And in the movie of my life, it would be 100% Jodie Foster. Yeah. Oh, everyone's like, oh, right. It would be Jodie Foster, right? Okay. Now, did you get an answer for that?
That's enough time for me to think of some.
Okay, good.
My name is Michael Rhodes. I'm a judge at the San Francisco Superior Court. I use he and him pronouns. And my movie of my life, I'm going with Neil Patrick Harris because he's very talented and much more talented than I am. And I've been an appellate attorney. If anyone can make being an appellate attorney exciting, it's Neil Patrick Harris. So that's who I'm going with.
All right, 100%. That sounds good. Shalak, you want to go next?
Yes, my name is Shalak Richards. I use she, her pronouns. We saying titles or just where we work? I'm sorry.
You can say the title and where you work, sure.
Okay, I'm
Sure,
Dean of
you're present.
I'm Dean of Students, Belonging and Career Development at Pepperdine Caruso School of Law. And in the movie of my life, on any given day, If it's a very dramatic day, I would be played by Viola Davis. If we're feeling a little bit more, you know, if it's the comedy of errors that are my life while still projecting tears, then Regina Hall. But if we really feel like kicking butt, then Regina King, which is a very important distinction.
I like all three of those choices for you, actually.
Thank you.
Novella.
Hi, I'm Novella Coleman, pronoun she, hers. I work at the California Civil Rights Department. If I picked an actor to play my life, it would be Keisha Knight Pulliam.
Oh, I can see that too. Thanks, Novella. Ryan.
Hi, everyone. I'm Ryan Harrison. I'm one of the terming out members. I'm a trial lawyer with Weber and Egbert Employment Law, and I'm the immediate past president of the Wiley Emanuel Bar Association of Sacramento County, and I also serve on the board of the California Association of Black Lawyers. I go by he, him pronouns, and in the movie of my life, I've been trying not to say this. I mean, I was going to say Michael B. Jordan, but I really want to say Will Smith. Yeah.
Thank you, Ryan. I like that choice too. Heather, I see you. So
hi, thank you for your patience.
Of course, we're doing name, pronouns, employer, and then who's going to play you in the movie of your life.
I heard all of that, and those were
Okay,
all
good.
great choices. That was awesome. I'm Heather Anderson. Her, she pronouns. I am the head of business affairs at ESPN, and also the Walt Disney Company. Not head of business affairs, but an attorney at the Walt Disney Company. And as much as I get Alicia Keys often, if I had my choice, it would be Angela Bassett.
Yeah, I like that choice too. Okay, I'm gonna make Sarah. You know, you were on COSO, and even though you're on the board of trustees now, and you're a liaison, I'm gonna make
You're gonna make me do this,
Yeah,
okay.
I am.
Hi, I'm Sarah Good. I'm a partner and chief talent and inclusion officer at Farella, Braun and Martel in San Francisco. I was a member of co-op until I joined the bar's board of trustees about 6 months ago. I'm now the board liaison, which is great, and I'm happy to be here in person with the folks here in San Francisco. And after consulting with my wife, because I am terrible in answering these kinds of questions, I'm going with Kate Blanchett. So.
Oh, yes. I kind of wish I had chosen Kate Blanchett now.
Anyway, delighted to meet the new members and also to say goodbyes to Ryan, Heather, and Sal, who have done such tremendous things for co-op. So thank you.
Okay, I think I got all the current co-op folks, right? All right, so incoming co-op members, Yemi Adebo Mary, you want to go first? I think Yemi, you're here, right?
Yes, sure, I can. Good morning, everyone. I'm happy to be here today. Good morning, Heather. Heather and I were colleagues at the Walt Disney Company. It's wonderful to see your face and see it in this context in particular.
So good to see you.
Yeah, so Yemi Adebo Mary, she, her pronouns. I am acting general counsel and VP over at the Missing Channel Media Group. And I am also a member of the national board of Lambda Legal. And if I had to pick, I'm gonna take a cue from whoever listed three folks. I love the presence of Tiffany Boone. You may know her from Hunters, as well as Little Fires Everywhere. Selma Hayek, love her fire. And then I have to stay true to my Disney family, Disney brand, and say Viola Davis. For her drama, her passion, and her ability to command a scene.
Thanks, Yemi. Welcome.
Thank you.
We're so glad to have you. Tara Davis.
Good morning, everyone. My name is Tara Davis. I am the Chief Diversity Officer
and Talent Development Officer at Kenobi Martins. I'm based in Irvine, California. I go by the pronouns she, her. And I would say if anyone were to play me in a movie, it would be a cross between Keke Palmer and Zooey Deschanel. They just embody the quirkiness that is my life, and just the boldness that also is my life.
Thanks, Tara. Welcome. I like those choices. Tristan Higgins. Hello, Tristan.
Hi, everybody. Can you hear me?
Yes.
Okay, I'm Tristan Higgins. I use she, her pronouns, but I go by mix. So just to keep you all thrown off if you're using honorifics. So mix in court, which always is fun for judges. Let's see, I'm down in San Diego. My court, let's see, what is my profession is lawyer. I'm feeling very, very honored to be in this group and a little bit humbled, but I'll hold on to that and keep quiet about that. I run my own firm called MedInclusive, and I do diversity, equity, and inclusion consulting. So it's my job to come in and talk to companies sort of like yours that aren't as advanced, and help get them to where it sounds like most of yours already are. So I do that consulting throughout the state and the country and sometimes the world. I'm very, very excited to be joining this group. Let's see, if I were to, oh, and I've been a lawyer for 25 years, in case that's not clear. Sometimes people think I'm too young because my wife has me on a good skin regimen. So if I were to be played by, I know I had a lot of time, but I still don't have a good answer. So I think I'm going to say, even though I don't think this well of myself, I'm going to say Gal Gadot, because not because I think that I look like her, but because I love Wonder Woman. And sometimes I also would say Leah Delaria, again, because I'm funnier than she is. So I think the combination between the two of them, I know this because I know her, and I think she would not agree with you, but you know, anyway, that's where I would say that between the two of them, I think this is sort of the combination of my life, either trying to be a superhero or trying to be funnier than everyone else in the room. So thank you.
Thanks, Tristan. Good to see you.
Nice to see you too.
All right, Jezreel.
Yes, hello everyone. I'm Jazarelle Hill. I go by she, her pronouns. I am an assistant clinical professor of law at Loyola Law School in Los Angeles. And let's see, I'm also gonna have to go with a combo answer for the actress that will play me. So I would first, who comes to mind is Jennifer Lopez, because that's the first Puerto Rican actress I can think of. And she has an incredible work ethic. And then I would throw in a little bit of Kerry Washington, because I was a huge Scandal fan, and she's, you know, very passionate actress. So that would be my answer. But I'm really excited to meet you all and to join the council and you know, continue to help support this work that you're doing.
Thanks, Jezreel. It's good to have you. Okay, so we're gonna make state bar staff, and I'm even gonna ask Judge Dulcich to do this as well. So I'm giving you a few minutes, Judge, to think about yours. But Elizabeth.
So
you have lots of time.
Yeah, no, thankfully, Judge Kristen gave me warning of what this question was before we started the meeting. And my first comment was, well, growing up, I didn't really have a lot of options. So I actually had to Google Asian actresses. But then she didn't come up on my Google search, but I'm gonna, I should introduce myself. My name is Elizabeth Hom. I'm a program director with the Office of Access and Inclusion. I'm primary staff to COAF, so I oversee a lot of the diversity, equity, and inclusion work that we do here. Our office also administers legal aid grants to nonprofits across California, and so I'm also involved in that work as well. I've been at the state bar for about 6 years now, and have been primary staff to COAF for about 5 of those years. So it's really very exciting to see kind of the injection of talent and dedication from all of our members, outgoing and incoming. My pronouns are she, her, and the person that would play me in the story of my life would be Ali Wong. Because I'm not as funny as she is, but she's from San Francisco, and I'm a San Francisco native. And I was her day camp leader when she was in the 2nd grade, or the 5th grade. In the 5th grade. So that's I like that. Yeah.
I like that. Okay, good. Shannon. You gotta go to Shannon.
I'm Shannon Crossley. I work at the State Bar's Office of Access and Inclusion. Pronouns are she, her. And I think I would be played by either Maya Rudolph or Rashida Jones.
I like that. Okay.
Those are good answers.
Yeah, those are good answers.
Those are really good answers.
Danielle, you're in, since you guys are up, you go now.
Sure, yes. I knew that this was the prompt. I did not realize staff would be asked to answer. But my name is Danielle McCrae. I'm a lead program analyst in the Office of Access and Inclusion, based in the State Bar's LA office, unsurprisingly. My pronouns are she, her, and I, like Elizabeth, went straight to Google and was looking up biracial or mixed race actresses, and one that stood out to me was Zendaya.
Good answer.
That's a good answer. Okay. Thanks, Danielle. Michael.
Hello.
He's like, I didn't know if I stayed on.
Yeah, I know. I was like, maybe I should have just turn my camera off. No. My name is Michael Chong. I'm a program analyst with the State Bar's Office of Access and Inclusion. I've been here a year, actually last week. Pronouns are he, him, and actor. I don't know. When I was a little bit younger, people would always say that I look like Bobby Lee because I would just be like goofy as hell. So I guess with that.
Thanks, Michael. Raul.
Hi, my name is Raul Duran. I'm Assistant General Counsel in the Office of General Counsel for the State Bar. I too had to Google, but I'm going to go with Wilmer Valderrama.
Oh, okay, good. Kimberly, see, you didn't log off, so I can see your name. I can't hear you though.
Okay, sorry. I thought being off camera was going to save me.
Yeah, I didn't.
Kimberly Wormsley, I work in Office Access Inclusion with Shannon and Elizabeth. Shannon and I work together, staff and assisting with the meetings. I go by she, her pronouns. Wow. I guess I would pick my favorite actress growing up as a kid was Pam Grier, but if I had to pick somebody that's still going now, I would go with Viola Davis.
I like Pam Grier too. Pam Grier, that's a good choice. All right, I think Judge Dulcich, you're last. I know how much you love being the liaison to COAF. So.
Hi, everyone. I'm Judge Judy Dulcich. I'm a Superior Court judge in the County of Kern, which is Bakersfield, California. I am your liaison from the Judicial Council's Advisory Committee on Providing Access and Fairness. Separate and apart from that, I have an advisory seat on the Judicial Council. I go by she, her pronouns. Movie of my life, the actress I would pick, and I'm going to date myself. I don't even know if you all will know who she is, but Gina Davis.
Oh, yeah.
Okay. What you don't know about me, what I love about her is she is a very tall woman. We have not met because I've always zoomed into our meetings. I am 6'3" tall.
Oh my God.
Yeah. And so I love that about her. And she's got that funny, witty Thelma and Louise thing going on. And I love that about her as well.
That's awesome. No, we haven't met. Maybe you can come to Los Angeles for our in-person meeting in December so we can see how tall you are in person. I wouldn't have known that. So.
LA is much closer for me.
Okay, well, thank you everyone for doing that. You know, we wanted folks to, get a chance to meet everyone, and this seemed like a fun exercise for the outgoing folks and the new incoming folks. Before we get to the to Elizabeth's report, I just want to take a second to acknowledge Heather and Ryan, who are both leaving. I'm going to try not to cry while I'm doing this. I'm going to try not to cry. So for the folks who, and I'm a crier, so for people who know me, that won't be a surprise. But, Heather and Ryan and Sal and I all came on together. And Sal is not here with us today, but Heather and Ryan and I worked on so many projects together, and so much of the agenda that you're going to see later in this meeting is because of Heather and Ryan. So much of the amazing work that we have done over the last 4 years is because of Heather and Ryan. And we are a better group because of these two individuals. And I am so sad. And I really tried very hard, and Elizabeth will attest, to try and keep them on. And I really twisted every body part Heather had to try and get Heather to stay too. And I wasn't successful. But I want both of you to know how much I appreciate you as colleagues, but really as people. And you know, we've had, you know, Ryan's had, you know, additions to his family since we've all been together. And, you know, Heather's had kids graduate from high school, and we've been through all of these life events together while in a pandemic, and barely able to see each other. But I want you both to know how much you mean to me and to COAF, and that we really truly are better because the two of you were here. And so I sent you both something. You know, the State Bar doesn't allow, the State Bar is going to send you a certificate. It's super cute, and I saw it. But the State Bar does not allow, doesn't give gifts at the end. But I talked to Michael, and we agreed that it ought to be. And so Michael and I did it ourselves. And so each of you have something there, which hopefully you didn't open, because I said on the box not to open it until right now. But I want you to know that that, you know, from COAF, from Michael and I, how much we appreciate the work that you did. And hopefully you got the right ones. I didn't get.
Do I open it now? Can I open it now?
You can open it now. Ryan's holding
Okay.
it up.
Yes.
Okay.
It's beautiful. Thank you so much. It means so much to me.
It is beautiful, and it is the right one. Thank
Oh,
you
good.
so much. It's like, this is gorgeous. Thank you.
So I again, you know, it breaks my heart that we're not going to be seeing each other on these meetings, but we will find a way to still see each other. But I wanted to give you each a moment, if you wanted it, to just to talk about what COAF has meant to you. And you know, Ryan, you want to go first?
Sure. Yeah. Serving on COAF has been such a tremendous honor. Dare I say, at this point in my career, the biggest honor of my life. The things we did to advance diversity in the legal profession were huge and momentous. The work that's currently ongoing is very important work, in particular, the imposter syndrome work to help you know, address these issues that result in promising folks from deciding not to go into the profession, right? We want to encourage this, and you know, my personal path to becoming an attorney had its ups and downs, and being able to serve on this committee and to have an impact with the State Bar and within the profession in California has meant so much to me. And I am just blessed to have been able to work with you guys in this process, and elbow to elbow doing this good work that we do. Judge Christian, you know, we are going to continue to, you know, call each other and text each other and continue this work, even with me not formally on this commission. And you know, serving as vice chair and then chair meant the world to me, and I'm glad I was able to have an impact. And I just feel blessed in this moment. And I'm looking at Michael now, and I met Michael before I was even a member of the bar, you know, at a bar and in San Francisco. And you know, just to see all the work we've done together now, and you know, him being appointed to the bench, and you know, this is such a great group, and I feel like this is being left in such great hands. So thank you all for helping me along the way, and thank you for allowing me to help you too. And Also you, Elizabeth, you know I love you, you know, so yeah, we'll be in touch too.
Thank you, Ryan.
Uh,
Yeah, we have a lot more work to do together, so. Heather, my love.
Yeah, I was gonna say, Judge Kristen, I don't know why you're emotional. You know, we're gonna all see each other like all the time. I heard you say the December meeting is in LA. I'll see you all then. So I'll make sure and get a chance hopefully to meet many of the new members in person too. But I echo everything that Ryan said. This is one of the joys of my life and my career. Tristan, I too have been practicing 26 years, and I know you can't tell, I look 26, right? But this has certainly been a highlight of my career to be able to see this really meaningful work originate here, get executed here, come to fruition, and really be impactful. And it takes this whole village. And the people before us. We came on when Judge Brenda and Judge Gary Roberts were rolling off and had some big shoes to fill just coming behind those co-op members. And it's the only reason that I could feel comfortable and confident leaving was hearing who all of the new members were going to be and knowing that you're going to be in great hands and this work is going to carry itself forward. But Ryan and I will be close. We are always here to consult. You will never have to, be worried that we're too far away. And it has been a blessing and an honor to be part of COAF. Thank you so much. And thank you for the beautiful award. That is gorgeous. I can't wait to put it in my office. Thank you.
Thanks, Heather. Okay. That's the emotional part. I got that out of the way early. Okay. I'm gonna get us back on track. And I will. Sarah knows I will too. Okay, it's your turn, Elizabeth.
Sure. And I also wanted to recognize Ryan and Heather and Sal and Kristen. When the four of you came on COAF, it was a really big transitional time for the state bar and for COAF, and I really just appreciate you injecting our little group here with enthusiasm and energy into the advancing DEI. And personally, I really just appreciated your kindness and your patience and your hard work to work alongside with staff. So we'll miss you, but I know you aren't far away, and we'll definitely be calling you to help us out. So thank you. And then for my report, I have two items that I wanted to provide updates on. The first is, as you remember, the Legal Services Trust Fund Commission. So that's the sub-entity that our office also staffs, and they oversee the grants administration. Earlier this year, they asked COAF to collaborate with them to review and make recommendations on applications for funding for summer law students at our legal aid organizations. So Novella and Kristen participated in that committee, and we were able to fund 80 law students at 38 legal aid organizations this summer. And it was very exciting. Staff was able to attend. We had a little closing session by Zoom with them, and it was really just lovely to see all those little squares on a screen, kind of the future of our legal profession. And so it was great to be able to fund them for the summer. We are going to have another round of funding for summer law students. And because our timing this year was a little bit late in the recruitment cycle, we're pushing it up a lot, and we're going to be working this fall on it. So thank you again to Novella and Kristen for participating on that committee again. We'll provide an update once we get a little further along in that process. And then the second update I wanted to provide is that some of you have worked on the law school retention study with our Office of Admissions. We will likely have a draft for our working group to review. And just as a reminder, that's Novella and Shalak. And so I'll be in touch in the next several weeks to let you know about that. So that is my report for now.
Thanks, Elizabeth. Okay, we're gonna start with our regular calendar, item 6.1. I think I just saw George. There's George. And George, Chief Trial Counsel, will be giving us a presentation on Rule 8.4.1.
So, yes, so hopefully now you can hear me.
Yes.
Okay, perfect. So if it's okay, I'll go ahead and share my screen. So can everybody see that now?
Not
No.
yet.
No.
No.
No. Okay. How about now?
Yes.
Yes.
Okay. This is an update on data regarding our cases involving Rule 8.4.1, and what I've tried to pull together with the assistance of our of MAD, the office in the State Bar that gathers data, is data that runs from November of 2018 through July 2023. So right after the new rules took effect in November of 2018, which was when Rule 8.4.1 took effect, through the end of July 2023. So if you'll remember, Rule 8.4.1 has 6 different allegations. We've identified 6 different allegation categories, and data is gathered and maintained around these 6 allegation categories. So we keep track of complaints that are identified by our staff who handle the intake of complaints as raising an allegation in one of these categories. The first 2 pertain to representing or terminating or refusing to represent a client. If in the course of doing that, there's unlawful harassment or discrimination on the basis of any protected characteristics, and those protected characteristics are defined in the rule, or if there's unlawful retaliation. The second set of allegations relates to law firm operations. If there's unlawful discrimination on the basis of any protected characteristic, unlawful harassment, or unlawful refusal to hire or employ, or unlawful retaliation. So those are basically our allegation categories. And the first 3 slides I have are data around the allegations. And so this is a pie chart that shows what has happened to those allegations for cases that have been filed, complaints that have been submitted between November 2018 and July of 2023. We've had 550 allegations that we've closed an intake, 211 that have moved to investigation have been closed, and 65 that remain open. Breaking those down, you can see that by far the most allegations come in category 1, that is that in representing or terminating or refusing to represent a client, there has been unlawful harassment or discrimination on the basis of any protected characteristic. That's far and away the largest set of allegations we get. That's the one on the far left. And then you can see what's happened, the relative numbers of all those allegations across those categories. I then gave a slide showing by year so that you can get a sense of how the number of allegations coming in has varied over the year. And what you'll see, not surprisingly, since this was a new rule in 2018, you'll see a gradual increase in the number of complaints coming in that have made this allegation over time. The last column is 2023. It's lower, but that's only for the first 7 months. And so if you project it out, you'd see that 136 would probably be close to the number in 2021 in terms of the number of allegations. So again, remember that these 3 slides relate to the number of allegations, not necessarily the number of complaints, because a complaint could have more than one category of allegation, and not attorneys, because an attorney could be subject to multiple allegations. So this is just looking at numbers of allegations. The next set of slides looks at unique attorneys. And so these are individual attorneys who during this time period faced at least one allegation falling within one of those 6 categories over that time period. So we did have a number of attorneys who may have been the subject of multiple allegations, either in one complaint or multiple complaints, but this is looking at just unique attorneys who have been the subject of an 8.4.1 allegation. And so you can see the numbers here. We've had 462 attorneys whose cases have been closed in intake, 175 who've been closed in investigation, and 45 that remain open. And then on a yearly basis, you can see a similar trend. If we look at attorneys as with allegations, we've seen an increase from 2018 through 2022 in the numbers of attorneys who have faced allegations under 8.4.1. And again, the column on the right is for just the first 7 months. So if you projected that out, we'd probably be right around 170, 180 for 2023, assuming that it continues for the rest of the year on the same trend. So that is basically where we are on the data. And with that, I am happy to try and answer any questions that people may have.
Questions for, again, sorry, Ryan, your hand is up. It's right over the.
Yes. Thank you, George. Thanks for the presentation and nice to see you again. Definitely appreciate your work. And I remember last year we got together and there was this video that was published about this rule and how it applies. Did we see an uptick in complaints since that video was published, or has it been relatively the same for the past 2 years?
I think it's been relatively the same for the past 2 years. As you'll see, we had kind of a big upward trend from 2018 through 2022. I can't remember when exactly in 2022 the video came out, but I don't think we saw a massive uptick after that. And the trend for this year is basically to be level with 2021 and 2022.
Okay, and my last question is, you covered complaints that were closed at investigation, and I was trying to figure out this, like whether or not they were closed because the standard was determined not to have been met to move forward with filing charges or making disciplinary recommendations. And what I mean by that is, I know that in order for an attorney disciplined by the state bar, you have to prove misconduct by clear and convincing evidence, versus like in civil court where you prove like harassment or discrimination by a preponderance of the evidence. So are you guys considering that standard in making the decision to close a complaint at the investigation stage based off of this clear and convincing evidentiary burden standard?
So yes, that's the standard we apply. We close an investigation if we conclude that there's not sufficient evidence to proceed to discipline and prove by clear and convincing evidence the allegations. So that would be the standard we apply in making a decision not to proceed past the investigation stage.
Okay, thank you.
So then, I'm sorry.
No, Michael.
Right. To follow up on Ryan's question, because I had, I think, the same question. Is there any data that you can share about disciplinary proceedings that were commenced as a result of these complaints?
I couldn't share specifics unless we've actually filed the charges, and unfortunately I don't have the data on how many cases have actually proceeded to charging. That wasn't in the data set that I got from MAD, but that's certainly something I can try and pull. If there would be an interest in that, to the extent we've filed charges, I could give you specifics. To the extent there are cases that are in the pre-filing stage, that is, they've moved past investigation and are now at the point where we're drafting the charges, I couldn't provide specifics, but could provide numbers on that.
I think that would be great, George, if you could.
Sure, I'll try and get that data as well.
Okay. I have a follow-up. Sorry, George. So when these investigations are closed because it's apparent that the clear and convincing evidentiary standard could not be met, and we send notification to the complainant, like we're closing this, is there some type of recommendation about maybe they should pursue other civil alternatives, or maybe find a lawyer to file in civil court? And right now I'm thinking of the employment discrimination context. And it also, is there some type of clarification to the complainant saying, hey, you know, we're abiding by a different standard here than a standard that would be applied in civil court?
Yeah, our closing letters typically include an explanation as to why we've closed. And so if it's based on the clear and convincing standard, typically we will tell them, you know, we've concluded for the following reasons that we can't establish this by clear and convincing evidence. And then typically there's a more detailed explanation as to why in particular we don't think we can prove a required element by clear and convincing evidence. We don't typically provide, since we don't provide legal advice in other contexts, we don't typically tell them or suggest that they speak to a lawyer about a civil case, because that's really outside of it's outside the scope of what we typically can do. In other words, we typically don't provide legal advice to people as to whether or not they should think about pursuing another type of legal action.
Okay, thanks.
a follow-up.
Wait, okay.
This is
Oh,
related
okay.
to that. It's the flip side of Ryan's question, which is if a complaint is closed that was filed against a particular attorney, are resources provided to that attorney with regard to what 8.4.1 requires? I think that this is done in the context of some other investigations related to trust fund operation and things like that, where even if there's not a complaint that's filed, there are resources provided so that folks have a better understanding of what the rules require.
So in certain instances, if we close cases with what we refer to as a resource letter, in other words, if we've made a determination based on the allegations that resources would be useful, we can include in the closing letter to the attorney a list of those resources. In client trust account cases, we recently made a policy change to do that in all client trust account cases. So we include resources in all our closing letters there. We don't currently do that in all 8.4.1 cases. So as of right now, we make a more individualized determination as to whether we think resources would be useful. And if so, we then include those in the letters, but they're not in all of our closing letters.
Thank you, and thanks for your patience.
Sure. Hi, George. Sarah Good here. I thought it might be useful perhaps for you to talk about, the number of complaints that actually get charged, through the system, kind of what that number looks like, because it's a very small fraction, folks.
Yeah, so typically,
but it might be interesting to know is, if complaints around this particular issue are charged at the same rate, or, at a differential, whether up or down, that might be, a better kind of gauge. So just a suggestion.
yeah, so I can certainly pull that. I mean, just so you know, on the general data, based on a study that was done last year, for complaints as a whole, roughly 63% close in intake, roughly 34% close in investigation, and roughly 4% proceed past investigation into the charging phase. So as Sarah said, it's a small part. It's basically a large funnel, and we funnel out larger numbers at each stage based on the investigation and what the evidence shows and the cases that we believe we can actually proceed and prove under that standard. That same standard applies to our other complaints as well. So Sarah, did that give that information that you wanted there? And
yeah, I thought it would be useful for co-op to hear that, so yeah.
Yeah, and I can certainly try and pull the data on our actual cases that proceeded to charging under this one, so that you can get a sense of the differential.
That'd be great, George, thank you. Michael has another question.
This is a follow-up and it might take us a little bit afield, but I think that the last time you were here, we talked about in terms of the data, I know we can't get too granular, but having an understanding of the types of, mainly the types of attorneys who were having complaints filed against them. And it's making me think of the new, I think it's 8.3 when it comes to reporting of attorney misconduct. I think that we had discussed at one of the last co-op meetings some concerns about folks that might take advantage of rules like 8.4.1 and I suppose potentially 8.3, but to see if there's any sort of disproportionate complaints being filed against attorneys, particularly smaller practice size attorneys, attorneys of color, things like that. I'm guessing, I know you don't have that data with you, but I suppose what I'm doing is putting a plug in that we might need to, we may be interested, or I'll say I am interested in hearing about
I think
that.
co-op is interested.
Okay.
So I can try and try and get that data pulled. I will tell you that in terms of data on practice size, our data going back in time is we don't have complete data on that. So you would get an incomplete data set. In other words, there'd be a number of attorneys as to whom we would just have unknown on their practice size because until recently, that information wasn't gathered in the same way. But I can certainly see what we can pull and get that included in the next data set.
Thank you.
And I just wanted to comment that the work of the ad hoc commission on the disciplinary system has been concluded, but it has not yet come to the Board of Trustees. And that work was looking at, among many things, disproportionate impact of the disciplinary system on BIPOC attorneys in California and various other things. So there's a lot more in process there to complete that. So.
Shalak?
Yes, thank you. I was going to add or ask two things. One, that's follow up to Judge Michael in asking, in addition to that disaggregation, I'd be curious if the data you could pull, George, would include years in practice. So whether or not this is being used more against younger attorneys versus attorneys who have been in practice for many years. And I guess where I'm going with that is leading to my second question, which is both to public and attorney education. So my question here is following up on Ryan's about the video. Are there plans to have that video or public education around the ability of the public to use this to protect themselves, put out sort of annually? And where does attorney education around this sit? And I guess that's why I'm curious about the years in practice, to see if younger attorneys are more aware or people going to them are more aware, and where that might sit both in disproportionate impact and making sure that everyone across the profession is being held accountable.
Yeah, so I can certainly see about adding years in practice as another data point. We do have that information, at least years in practice in California. So it would pick up, we could get that. In terms of the video and education, the video remains posted on our website, so that's available. It's one of the, it was one of the original kind of short video clips that was put together, along with a couple of other rules to be up on the video to provide a more kind of a more user-friendly way to learn about the rules. So that has remained up on our website. In terms of other education efforts, I can certainly talk with OPC and see what they have in the works on Rule 8.4.1.
Thank you.
Thanks, George. Any other questions for George? Okay, I don't see any. Thank you, George. I appreciate you taking the time, and it sounds like we're going to see you again in December.
Sounds like it. So I will see you then. I'll try and get as much of this kind of disaggregated data as I can.
Thank you. I appreciate that.
Sure.
Okay. Item 6.2 we're putting off until after lunch. That's on the future of the bar exam. Item 6.3 is the leadership seal. Danielle.
Yes. So I will share my screen if you'll give me just a moment to pull it up. Great. Okay. So my name is Danielle McCrae, and I'm a lead program analyst in the Office of Access and Inclusion. And I, along with Elizabeth, are here today to provide an update on the DEI Leadership Seal program. As many of you well know, this program is a seal or certificate program that is available to all legal employers that employ California attorneys, including law firms of all sizes, in-house legal departments, law schools, nonprofits, government agencies, and so forth. And to be part of this DEI Leadership Seal program, an employer must commit to at least 5 of a list of 10 DEI action items or best practices. After making that public commitment, the employer then has a year to implement 5 or more action items to then be a seal recipient, and they can use the seal on their own promotional materials, their website, their job postings, and so forth. And we have various tiers of the seal. Employers who implement 5 or more action items are a bronze seal recipient. 7 or more would get you silver seal, and then 9 or more would be a gold tier seal recipient. And so since our last meeting, or since the last COAF meeting, we officially announced the first cohort of committed participating employers and seal recipients. The program was launched in January. Those applications were due at the end of March, and then we announced that cohort in mid-June, so just after the last COAF meeting. And in that first cohort, the State Bar was able to announce 77 seal recipients and participating employers, which we were super excited about. 34 of those are seal recipients that have already implemented at least 5 of the action items, and 43 are committed participating employers that have publicly committed to implementing at least 5 of those action items. And so I wanted to put the list of seal recipients in front of you today. I won't read them all to you, but as I go through the slides, you'll see that there are some law firms, there are some nonprofit organizations, some of our legal aid grantees. And so these are gold seal recipients. There are 10 of them. And then I believe there are 14, if my quick math is correct, of the silver seal recipients.
And you'll see on the corner of the slide that our communications team did a really excellent job helping us with branding, so that we would have tools for these recipients to kind of show the community and their clients and others their participation in it. And so so you'll see in the corner, like it changes for each tier.
Yes. And I believe on the screen, the little camera might be over it, so I apologize for that. But we can send the seals to you if you would like to see them. They're also on the State Bar website. And these are bronze seal recipients. And I have the Weber Law Group bolded because that is Ryan's employer. And so wanted to give them a special shout out.
Thank you so much.
Of course, thank you. Great. And so some of the things that we've been working on and are continuing to work on since the last COAF meeting, we are working on providing interim opportunities for participating employers and seal recipients to submit documentation before the implementation window closes. So after that first application window, those that are committed participating employers have a year to implement the action items. But if there are employers that are able to implement 5 or more action items more quickly and they don't want to wait until next spring or summer to get the seal, they can submit those materials to us. Also, current seal recipients, if they've implemented more action items that would allow them to move up to a higher tier seal, we're also allowing them to submit those materials. And so we have 3 scheduled windows for our staff to review those materials, the first of which was this month. Then there will be another one in November of this year and one in February of next year. For that August window, we had 2 seal recipients submit materials in an effort to move up to a higher tier. We are still in the process of reviewing and verifying those documents, but if I remember correctly, there's 1 bronze tier recipient who is aiming to move up to gold, and then there's 1 silver tier recipient aiming to move up to gold. Another thing that we are working on is continuing to meet with stakeholders to identify and develop additional program benefits so we can make this program as attractive to employers as we can. We've had meetings with folks at California Lawyers Association and also presented in recent meetings of the Committee of State Bar Accredited and Registered Law Schools and also the Law School Council. We also are planning a diversity summit for later this year. We're still working on scheduling, but it looks like we're narrowing down to early December, very beginning of December before we get really in the thick of the holidays. As a preview, I'll say it now, at the end of the presentation, I will ask if there are any volunteers that want to help plan the Diversity Summit. So you can think about your interest in doing that as we work through the next couple slides. And then in those conversations with folks, with stakeholders, and also internally, we've come up with some additional ideas for potential benefits and also resources that we can make available to employers in the program. And I would absolutely invite your feedback on any or all of these. Some of the additional benefits that we've discussed are creating template recruiting materials for SEAL recipients to use at law schools, career fairs, something that kind of gets those materials started for them that says, firm X is a SEAL recipient, and this is what that means, to put this in front of potential employees or applicants. Also, something that we talked with CLA about and we're super excited about is the possibility for having a designation on their job board. And also, we're still investigating whether that would be an option for other association or affinity job boards. But the goal or idea here is being able to indicate in some way those SEAL recipients, if they have job postings, that they are a SEAL recipient when folks are looking at their postings on the job board. And also facilitating recruiting webinars or opportunities with those local and affinity bars, specifically for the SEAL recipients, again, kind of in tandem with that job board opportunity. And then in terms of additional resources that have been asked for or that we've talked about, providing technical assistance sessions to help employers compile and prepare their verification materials or their application materials generally before the next application deadline next spring. And also, particularly when we were talking with the law schools, there was an interest in providing or creating some sector-specific resource guides or FAQs, recognizing that some of the action items in the DEI Leadership SEAL program are maybe a little bit harder to implement in the law school context, or maybe need a little bit of creativity to think through how they will apply in the law school context. And so thinking through what types of materials that we can potentially provide to those folks to make the program a bit more accessible. I'll stop there if there are any questions or thoughts on these additional ideas for benefits and resources, or if there are things that are not on this slide that you think we should investigate as well. Michael?
I would just add for a sector-specific resource guide, government agencies.
Great, yes. We had, I'm trying to recall, I think we had 6-ish, maybe, I think about 6 government agencies apply in the first cohort that were split across SEAL recipients and committed employers. And so that is a smaller group that I think could benefit from some additional TA. So thank you for that.
Danielle, any other questions for Danielle? Yemi. Oh, Yemi.
Hi, good morning, everyone. Just have a quick question. If folks sort of begin to fall short of the, signal that the SEAL gives, is there any process around that? Grievance verification. I'm taking this all in new, so I may be asking a question that may not need to be asked, but I was just a little curious to know what happens if on the retail side, the experience is different than what the SEAL indicates.
Absolutely. I think that's a great question. Because it's the first cohort, we haven't yet finalized what annual recertification or reapplication or re-verification will look like. That's something that we'll need to sort through in the next couple of months. And so I think that's something really important for us to keep in mind of how do we ensure that employers are continuing to implement these action items. Maybe one piece of information that's helpful to know or as context is the State Bar, when we were developing this program, was really careful when we are reviewing the documentation that's submitted as part of verification to not necessarily make a value judgment on the strength of their strategic plan, for example, or what some of those materials that they needed to submit were. We didn't feel like we were best suited to make that value judgment. And so that's just something we'll need to keep in mind as we continue to think through how we verify employers are continuing to do this work meaningfully, what the State Bar's role is in doing that verification. But I think that's super fair and something we'll need to wrestle with as we approach the next application cycle. Shalak, yes.
Yeah. I'm just curious about the sector-specific resource guides, and I think not just for law schools, but higher ed in general, but then I also think about within the private firm context, and I know we talked about this a little bit when you all were developing it, what that could look like for the smaller firm that might be, you know, solo or small, right? Up to 5 maybe attorneys and a few staff members versus a lot of the larger firms that were on the list that might find some of these things more accessible to do. So as you think about what types of flex might be needed in the higher ed or law school context, I just encourage the state bar to think about that in terms of firm size and sort of anecdotally in providing support to graduating students and alumni that I know who are very committed to DEI work, want to see it through their firms, but also say, we're not at a large firm with a formal HR department and sort of all these things where it might be easier for some of those large firms to do this. They're very curious about what they can do. I mean, I think this is an opportunity for the bar.
Yes, I think that's great. In the first application cycle, we had at least one, probably a couple, solo practitioners reach out and ask, you know, what this might mean for them. And so that is something that we are continuing to investigate. And I think, yeah, that's another opportunity for, it's not quite sector specific, but, you know, employer type specific resources. I think that's a great idea. Yes. Thank you.
So I want to chime in. My firm has 4 lawyers. So it's, I think, considered a pretty small firm. And the process I was involved in it, and it was pretty straightforward. It didn't require a lot of work at all.
Great. That's good to hear that it was not overly challenging, even as a smaller firm. Great. Okay. And I have 1 or 2 more slides. Just 1. In terms of next steps, where we go from here, we're continuing to have these discussions about additional benefits and resources, and also actually implement some of these new benefits where we can. We're also continuing to review program goals that we set before the first application cycle and make sure that we're tracking our progress towards those goals, reassessing those goals, and, you know, making them more ambitious if needed, in the same kind of spirit of a continuous improvement that we're asking of the employers. As I mentioned earlier, we are preparing for a diversity summit later this year and would love if there are any volunteers that would assist with planning that. We also endeavor to assess whether we should introduce application fees in the next application cycle. And that's because the Board of Trustees wants this program to be cost neutral. And so it requires staff time. And so we're trying to kind of identify what those potential income streams could be or could look like. And finally, continuing to provide technical assistance and guidance to both the committed employers who will need to implement these action items over the next several months, and also interested employers who may want to apply for the first time before that next application deadline in the spring. So that is the end of the slides. We'll now take volunteers at this time if there are any, and also any additional questions or thoughts about where we should go next with this program.
Well, I want to commend all of you for this. I remember sitting in on a couple of calls about this, and I'm so excited that you all got this rolled out. I feel like really quickly. And so I commend you, Danielle and Elizabeth and team for doing that.
Folks, this is really Elizabeth's brainchild. It's a COAF. I mean, this came out of COAF. So when I say to you, think, you know, you can make a difference, you know, this is something that came directly out of COAF, just like the data set info for 8.4.1 came out of COAF. So yes, Shalon, to your point.
Yeah, and you all just did it, like you turned it around so quickly. And so thank you. And I want to be as involved as you will allow me to be, an unofficial employee of the state bar on this, because I believe strongly in it, and that, as I'm sure we'll bring up in other contexts throughout this meeting, that as much as we can do to positively speak to the benefits of diversity, equity, inclusion, justice, belonging in our current societal framework, we need to, and positive reinforcement is just as required as disciplinary action. So anything I can do, I would love to. Depending on the date of the diversity summit, I'd love to be involved with that as well, as long as personal things don't preclude involvement in that. So sign me up, Jack. I don't know if that's the right cultural.
Michael's raising his hand as well.
Wonderful.
Oh, that's it. That's it. We can't have more than two because then there's an issue.
Yes. Before we move on, I did, if you'll indulge me, I realized one of the firms was spelled incorrectly on the slide. And so just because it is a public meeting, I want to make sure they're appropriately recognized. Titman Wykes here at the bottom, this was spelled with a Z earlier. And so I just want to make sure we have their correct name up there and they get proper acknowledgement for being a gold seal recipient.
Thank you, Danielle.
Of course.
Okay, anything else for Danielle on this?
I just wanted to address, oh, I'm sorry, I didn't raise my hand.
Yeah, sorry, I couldn't see it.
I wanted to address the question about application fees. I think we should think long and hard about that because I don't want to discourage companies, firms, organizations to apply for the seal process, but when they accomplish it, if there's something we can provide to them and maybe there is a fee for that, something equivalent to the beautiful award that we just received, Ryan and I, that it's like, if you want something to display in your offices, we can create that, but there's a fee for that. And then after they've already accomplished the seal, they would get some reward for that. Maybe that's where we place the fee. So just food for thought.
That's helpful. Yeah, something that we've talked about too, because we also want to be sensitive to not make those application fees so high that it's a barrier. I think there's been discussion about only having application fees for private sector applicants, but then that has different equity concerns potentially. And then the other point I wanted to respond to was one of the ideas I had put up on, or we had presented on the slide, was around offering technical assistance sessions to help folks kind of get their documents ready to go. There was a discussion around whether we should or could charge for that type of more in-depth technical assistance as an opportunity to offset some of the costs of the program. But again, we haven't, we're at the beginning stages of those conversations and what that means for equity in the program.
Thanks, Danielle. Okay, no more questions. Okay, I don't see any hands either. So we'll move on to LRAP.
Great. So loan repayment assistance programs, as you all know, we worked with the Legal Services Trust Fund Commission and the Access to Justice Commission to develop an LRAP proposal that was in the state budget last year. And that was really significant and we were very excited. Unfortunately, the governor took it out at the last moment. And so for the budget cycle this year, the Access Commission requested funding so that they could administer an LRAP. And as a result, the IOLTA statute was amended. So for those of you who don't know, the IOLTA statute is interest on lawyer trust accounts. The revenue earned on those accounts are the state bar uses the revenue on those trust accounts to fund legal aid organizations throughout the state. For over the last several years, that revenue has been very high because of interest rates have been high. So we've been able to do a lot of really good work in that space. And so after the IOLTA statute was amended, the Trust Fund Commission, COAF, and SAFER staff, we reviewed the language and found that there would be some difficulties in implementing the statute as amended. And so we did meet with legislative staff along with our colleagues in the Access Commission and the Legal Aid Association of California to express those concerns and seek some clarity. After that meeting, COAF, the Trust Fund Commission, and staff advanced language that we hoped would be able to make implementation possible. And then we also understand that the Access Commission advanced language separately and we haven't heard back. So that's my update. I don't know, Kristen, do you have more to add?
I have a lot more to add, but I'm not going to. Because, well, because you said everything there was to say, which is that, and again, this is another idea, and I highlight this again for the incoming members. This was a COAF idea. And Heather and Elizabeth and I worked on this for years And it came out of a COAF meeting. So LRAP exists now for legal aid attorneys because of the work that COAF did. And again, if, you know, I can't highlight enough how important the work is that we do here. And it exists in a different form, and maybe not in a perfect form, but it exists right now because of the people in this group. I'm just gonna say that I am glad it exists, and there's a lot of room for more work to be done in this area and to improve the work that has been done. All right.
Can I add one more thing?
You may.
I also wanted to add that there had been a statutory loan repayment assistance program that was unfunded, and this year the Student Aid Commission would administer, and this year that statutory LRAP became funded. So my understanding is that they're developing the program now, and so the Student Aid Commission has reached out to the State Bar, so we'll be participating in their efforts of helping them to develop their program, and so I will keep COAF posted on those developments.
Great, thank you. Okay. Pipeline to the profession. Another awesome COAF idea.
Yes. So I want to thank Heather and Ryan and Kristen for being the working group on this. Heather, especially for your facilitation and hard work in getting our latest outreach video developed. We were, with your assistance, we were able to interview Rhonda Hort, the head of legal at Lucasfilm, and Heather and Ryan actually were our excellent interviewers. That video is about 40 minutes long, but Heather was able to get us what I learned is called a sizzle reel. If you don't mind, I'd like to play that for us now. It's about 1 minute and 40-ish seconds.
This is my first time seeing it.
On two.
Oh no, for some reason I'm not able to share the sound. Oh, because I'm not. Oh.
Are you not a co-host?
No, I am, but I have my sound off because it would give feedback. So let me send this to Shannon and ask that she play it with the sound. And while we're doing that, we did have a working group meeting to talk about kind of future plans.
Yes.
And so, do you mind, Kristen, kind of talking about our potential future plans by
Sure.
send this on? Okay.
So, so again, another brilliant idea that came out of COAF, and really, and because we have so many brilliant people in the entertainment industry on COAF as well, that you know, this project is really a great one, and we have, you know, we've done prior videos, and then we have this one, which will show you that are on the State Bar website to really encourage future lawyers in this space. So we've talked about, you know, these are big projects, and we were fortunate that Disney, ESPN helped us underwrite all of these projects and really, you know, took the lead on that. But we also talked about in the working group ways in which we can encourage videos like this to be shot by individual attorneys. And so, you know, are there other ways to do this that aren't quite as fancy and expensive, but also speak to a younger generation, of which I am not. Ways in which we can put things on TikTok and really have attorneys talk about what they do, and you know, and talk about their path in short little snippets and not a long 40-minute video. And so we sort of kicked around with the communications folks who are also brilliant in this space, you know, ways to do that. and what this portion of our work plan could look like in the future moving forward. And I see Michael has his hand up.
My suggestion would be potentially barristers associations or barristers sections of county bars, which are typically 10 years of practice or younger. I imagine those folks would have really creative ideas and know how to do TikTok videos in ways that we don't, that I don't, I should say.
Right, and they can be shot, I mean, people shoot really impressive stuff on their phones these days. Again, I am not one of them, but I understand the young people today are doing that. And so, we talked about what's already sort of in the state bar's sort of toolkit of things they can do, and then things like that, reaching out to other associations and making it easy for those videos to be shot and talked about, maybe throwing out a sample question to them and then having them respond to that question, or having a couple of questions and then letting them pick one. And then just making a short video and having those sort of compilations on the State Bar's website, so people, young people can sort of see that. Ryan, is there more that we talked about, or Heather? I'm doing this off the cuff because I thought Elizabeth.
Yeah, we definitely.
I'm remembering what we talked about while I was in the car, and
we just, we talked about that originally. The concept was some of this was classroom learning. So the reason why the videos were 30 to 40 minutes long was because they were going to be utilized in high school classrooms, college classrooms as, a starting point for conversation. But as we think about how we could leverage so many other people's stories and expertise and attract in the bite-sized ways, the attention of younger people in the pipeline, we did start to have these conversations about pivoting the platform and the format and the style to shorter, digestible TikTok videos, which then would allow all of you to submit videos, and we could encourage our friends. I think we all know really interesting people who are practicing in traditional and non-traditional ways, that we could start to build this treasure chest and a repository of these videos that might be more digestible in faster ways for younger people to take advantage of. So they're dual purpose in the ways that we've been looking at it and the way we're looking at it future facing, and taking into consideration the production elements of it too. Although when you do the video yourself, you also have to do your own hair and makeup, which Ryan and I appreciated that we didn't have to do.
Okay, so we're
the longer
gonna show
videos.
the sizzle reel now, and I want you, I don't know if you can see Heather's shoes in the sizzle reel because I haven't seen it, but I want you to look at, as you're watching this amazing sizzle reel, see how good Ryan and Heather look in this thing. In Heather's shoes, especially, if you can see it. That's also, by the way, a COAF tagline that Sal came up with: "Be a lawyer, make a difference."
Mikey, we don't hear it.
Also not playing. Is there music?
Is that working?
No, we don't hear it.
State Bar. Oh.
1 second, I'm trying to find the share sound.
We did try to practice this morning too.
We did practice this morning, yes.
Technology is hard.
It is.
You know, it's not giving me the option to share sound.
Mikey, I can try.
Thank you.
Because we have a break, I don't know if we've connected with the Chiefs Power of Democracy program, which is.
I don't think that was on our list, but we have a list.
For the in-classroom portion, that might be.
Yeah, I know we talked about going to Cal Law and a bunch of other pieces.
Can you guys hear it?
Is there music in the background?
Yeah, we cannot hear it. Did you?
Can't hear it.
Share sound on the share screen.
Well, we also have a minute, Judge
Kristen, I just heard you mention Cal Law, and I'm not sure if you all are aware that a sort of separate offshoot nonprofit has started, the California, I'm forgetting, but it's specifically for high schools, and it's with the California Lawyers Association is a partner in that. They've asked me to be part of it, so I'm happy to share that information because I think these videos and other resources would be great because it's specifically for high schools.
That'd be great, Shalak. Can you send that to Elizabeth?
Yeah, will do.
That'd be great.
Excellent. That's what I was going to share. It's called the Diverse Voices of the Legal Profession. And,
Tristan, we might actually be discussing 2 different ones. Hold on.
Oh, really?
Which is
really?
exciting. I mean, I want as many as possible.
Oh, I'm so sorry if we are.
Can you hear the video now?
This is the California Legal Pathways Collaborative.
Oh, forgive me. No, that's something different. I'm sorry.
No, that's great because then Tristan, we can sort of blanket every high school, it sounds like.
Yeah, the California Lawyers Association has a video project that we've been working on for a couple of years called the Diverse Voices of the Legal Profession. And we have, I don't know, maybe 10 videos. They're like a minute or 2, maybe 3. They're very short. The CLA can record them for you if you want, or you can do them yourselves. And they're really very impactful. Oh, I'm sorry. I need to get them out of the background, don't I?
No.
No, not at all.
Oh, I thought because we were open to the public, I had to make sure there was no cats or dogs in the background. No.
We have never had that rule.
Okay. Well, that's great for me because I have a lot of animals here at this house. But yeah, it's a pretty cool. So far, we have 13 of them, and they're pretty neat.
Can you send us the link to that, please, Tristan? We
I
would love it. And this is why the influx of new people is so amazing. Because see, we all just learned something new.
Yes, I can.
Okay.
Is that working?
No.
Do we need to be muted, maybe, Sarah asked?
I can also leave the room and try to do it outside. I'm gonna try that.
Okay, Elizabeth's gonna leave the room.
And try to join and just share my video.
Okay. All right. Do you want me to take Alexa while you're doing that?
If Alexa is ready, that would be great.
Alexa? There you go.
Hi, yeah.
Can you do your quick update on the imposter resources while we try to get this working?
Absolutely.
Thank you.
Yeah,
Thanks for being flexible.
Of course. Bear with me as I share my screen. Great. Are we able to see this?
No.
Oh, great.
Oh, now
It's coming up. It's coming.
Okay. Perfect. Oops. Tech issues today. Great. Good morning, everyone. My name is Alexa Montalvo, and I'm a program analyst at the Office of Access and Inclusion. And I'm here today to share an update on the Imposter Syndrome resources or toolkit that the Working Group on Imposter Syndrome is working to create. To begin, I wanted to remind folks of what imposter syndrome is and why the State Bar chose to address this issue. Imposter syndrome is a term that describes high-achieving individuals who, despite their objective successes, cannot internalize their success, which leads to feelings of self-doubt related to one's intellect, skills, or accomplishments. The need to address imposter syndrome in the legal profession arose from the State Bar's strategic plan to support retention, development, and advancement of diverse legal profession, with a focus on preventative measures to address disproportionate complaint and discipline rates. To support this initiative, the Council on Access and Fairness, COAF, created a working group comprised of COAF members and State Bar staff from the Office of Access and Inclusion and OPC, with guidance from UC Davis and UC Davis School of Law to develop a toolkit with resources on how to address and combat imposter syndrome in the legal profession. The toolkit will be comprised of various articles, a worksheet, and video testimonials from attorneys across the legal profession to share their experience with combating imposter syndrome. And the goal of the toolkit is to have the resources be used from folks across the legal profession to use the resources to address imposter syndrome and potentially take proactive measures to curb it before it even begins.
And I would like to thank the working group, Ryan, Stephanie, and Shalak for all of their work and patience as we get this project moving along. So our update is that through the research, State Bar staff was able to meet with a group of attorneys, Suzanne Arnowitz, Melissa Tureau, and Parna Mehrabani from Oregon, who shared their expertise on imposter syndrome in the legal profession. They've done a lot of work in Oregon to create resources and toolkits of their own to address that employers and folks across the legal profession with the same goal of similar to what we were trying to do. And we had a really great discussion on the institutional practices contributing to imposter syndrome and ways to address the feeling and how to curb it in the workplace proactively. The group was able to share some guidance and resources that staff plans to include in the State Bar's Imposter Syndrome Resource Toolkit. And currently staff is working to finalize the toolkit with OPC with the goal of the webpage going live by the end of the quarter.
I just wanted to clarify that OPC is the Office of Professional Competence, and they're also developing additional resources around that would be useful for attorneys, including maybe wellness type, financial management type resources. So this would fit into those overall resources.
Thank you, Elizabeth. But yes, if there's no question, or are there any questions, any comments from the working group?
I can't see any. Elizabeth, do you see any?
I don't see any.
Okay, great. Thanks, thanks, Alexa. Appreciate that.
Great,
All right,
thank you.
we're gonna give it a shot again.
Yes, I'm going to try to share the video now. Oh, okay. For some reason, Shannon, I'm not able to share sound. Do you know?
No, I'm not sure why that's not working.
Oh, okay. So unfortunately, I don't think we can share the video because none of us are able to share the sound today. So we will send that out to you when we have it posted.
Does Heather have it?
Elizabeth, can you can you have, what do you call it? Can you have it like dubbed with the words at least so that we can watch the video?
I don't think the sizzle reel had subtitles because.
Does it have subtitles?
I believe those would be added before we posted them to our social media.
Okay.
I learned a lot about subtitles from Heather the other day in the working group meeting. And that's something that gets added by not Disney.
To be clear, what I said was it's not added by the content creator, it's added at the platform level. So wherever the video is going to be posted, it gets added. So when that is Disney, when it is our platform, we add the subtitles there. When it's a different platform like YouTube or something, it's the platform adds those. So when it's on the State Bar website, the State Bar will add those.
Do you have the sizzle reel, Heather?
I don't, because I'm on my iPad, so I don't have it.
Okay, well, do you want to, Elizabeth, you're welcome. We can try again after lunch if you want. We can troubleshoot it. You're gone, and now you're coming back right behind me. It's so creepy. You're right there.
Yeah, we can try again after lunch.
We'll try again after lunch. We'll work on it. But we're on 6.7 now. Sorry. Which is the MCLE module.
Oh, so that for the MCLE module, as some of you know, we worked on developing an implicit bias MCLE module after we had worked on revising the State Bar rules to increase the elimination of bias requirement from 1 hour to 2 hours for attorneys. And so that module will be 3 years old in 2025. And so with the MCLE cycle being every 3 years for attorneys, the thought is that we would update the implicit bias module. And so I think most of the work will be done in 2024 on that. We'll engage with the subject matter expert. Excuse me, and I know that Angelica and Novella, they're our working group on it, and they've talked a little bit about like what we can do to update it, or if we wanted to include any other topics in the module. So that is continuing.
Okay, and I see Lauren And then, so I see Lauren and we're pushing up against the time that we were gonna break for lunch. But what I wanna do is do Lauren and then Judge Dolcich, I want you to go out before we break for lunch, because I know you've got, so after Lauren, we'll skip to you. Is that perfect? Thank you. Okay, Lauren. Thanks.
Okay, thank you. Let me share screen. And present. Okay, great. Hello, everyone. My name is Lauren McGarry. I am a senior program analyst in the Office of Access and Inclusion. And today I'm just going to present briefly on innovative diversity, equity, and inclusion practices research. So first, I want to start out by providing some background for the research, and then I'm going to move on to discussing some of the major findings, and then we'll have some ideas to consider. This is based on the research, and then next steps, in which I'll be asking for your feedback as well as volunteers to form a working group. So just as a reminder, the State Bar's strategic plan has goal 2, which is to protect the public by enhancing access to and inclusion in the legal system, specifically increasing access to the legal system through public outreach and education, improved access to legal advice and services, and a legal profession that reflects the diversity of California communities. So also, the State Bar has its strategic operational plan, and this is also in COAF's work plan, where it states that we would do the review of innovative DEI practices from other industries that may be adaptable to the profession. So this is really the motivation behind the research that I'm presenting on today. It comes from these strategic plans and strategies that the State Bar has articulated. Also, just as a reminder, we all know of the current DEI work that the State Bar is doing in terms of the report card, the leadership seal, all of the publications that the State Bar has done. And all of that was a starting place for this research, as well as I looked at other industries to determine whether they are also participating in similar initiatives and work. So that was really helpful in informing the research and led me to the question of how we can make this current work even more impactful, or how we can expand on it to continue to advance the State Bar's goals. So the research findings are split up into 2 kind of categories. The first is practices that are consistent with the State Bar's current initiatives. So things that are really not that different from what they're doing in other industries. And then there are the innovative practices. So what I found is other industries have very similar initiatives, but perhaps they have a different approach to it. So I'm going to present on some of those findings, as well as even a new kind of practice that the State Bar might consider adopting. So in terms of practices that are consistent with the State Bar's initiatives, we have groups leading the organization's DEI work. So I found when I looked at other professions, a lot of times they had their version of like a COAF, right? So that's very, consistent with common practice. And then other organizations do DEI specific strategic plans. Also very common that these DEI specific strategic plans are communicating specificity around the organization's plans to accomplish its DEI goals for their professionals. And then lastly, diversity summits. Diversity summits are an opportunity to gather members of the profession, discuss challenges and best practices. This I also frequently saw when I looked at other industries and organizations leading that work in other industries. So now I want to talk about some innovative practices. These are some of the things that we have not done at the State Bar, but some of the things that could inform our practices going forward. So one approach is the publication of individual agency profiles, highlighting their processes and outcomes. This particular finding comes from the Government Alliance on Race and Equity. And what they did is in their publication of like their resource guide, their best practices, they included like individual profiles of government agencies who are doing their DEI work, their processes, their outcomes. And this is really important because it brings that real world context to these best practices that are being promoted, right? And showing how this actually looks, and it's not just a theoretical best practice. Another thing I found was publication that a historical context was included in addition to the recommendations for DEI strategies. So in this case, it came out of the tech industry, where they have what's called the ACT report. And that in that report, they offer their recommendations for how tech companies ought to continue to advance DEI. But as part of that report, they also acknowledge the history of it and why the industry has not been very diverse and inclusive historically. And I think that's important as it gives greater context for the work and the recommendations being put forth. Something similar could be applicable to, let's say, like our calls to action publication. And then the third thing I found was around reporting requirements for programs that are similar to our DEI Leadership Seal program, for instance. So a requirement to one of the organizations, they have their DEI Leadership Seal-like program, and they require quarterly reports, which are not at all punitive, nothing like that, not evaluations, but just an opportunity for those participants to communicate back to the leading agency some of the successes and challenges. And what the leading agency does with that information gathers is they came up with a final report to share out with the larger community. And then that also informed the program going forward. So it helped them to create, to improve on the program that going forward in the years to come. And then I also found there was this online reporting tool one of the organizations had, and they use it to collect DEI best practices information. This is just accessible on their website, inviting professionals to share with them how they're able to bring DEI to the profession. Another practice that I thought was, really interesting to consider was the American Hospital Association. They have their Institute for Diversity and Health Equity, and they came up with a continuum, which basically explains the process for adopting and really fully realizing the potential of a particular action. So this continuum, it describes exploring, committing, immersing, affirming, transforming. Those are different phases of fully adopting an action. And just to give you a sense of what that actually looks like, I went ahead and, for illustrative purposes, I came up with something that might be applicable in our context. So we have, let's say, we have our DEI Leadership Seal action item. We have conduct staff stay and exit interviews as one of the action items. So maybe exploring phase of that continuum would be organization leaders studying the extent to which the stay and exit interviews elicit feedback on workplace culture and inclusion. So maybe it's first even having the conversation around those interviews, or if they don't exist, it's having a conversation about creating those interviews. And then committing is actually putting the resources into making sure that the opportunity for those interviews is there. So it's moving forward with implementing interviews. Immersing would be something like doing the actual implementation. And then affirming would be something like doing the self-assessment. So seeing, okay, are these interviews that we implemented actually leading to meaningful feedback? And therefore, are we using that information to make a difference in the workplace policy and practice? And then transforming is actually realizing better outcomes for the staff. So again, that's just one example of how a simple action item like conduct staff stay and exit interviews, it can actually be broken down into pieces to be even more explicit about how an organization can really fulfill the fullest potential of that action item. And then for this last one comes from the Institute for Diversity and Ethics in Sport. They have their diversity report card in which they have like the way they graphically designed it. They're able to give you a sense for the direction that things are going in. So this comes from the MBA's report card from 2022, and they just like are indicating, okay, what was the percentage in the previous year? What's the percentage in the current year? And then just showing you like, okay, we've seen improvements in this area, or we've seen greater representation in this metric. And then also the image on the right from the same report, they actually also use letter grades as a way to indicate kind of where the organization is in their DEI. And that's a way to easily communicate to the audience, you know, how well one is doing in that particular area. And also, again, they have arrows to show whether that things are actually improving and moving in a positive way. Okay, so lastly, I want to go over some ideas to consider. All of these are based on the things that I've already presented on and talked about, so I'm not going to go into super detail. But yeah, so in terms of enhancing the State Bar's DEI publications, we could do the identification of successful individual examples of legal employers promoting DEI in their workplaces. Also, we could include a section on promoting what works, acknowledging the history and what are some things that have and have not worked, and why the status of DEI is what it is today. Formatting the diversity report card to emphasize metrics that show where there are improvements, or also maybe where things are not improving. So just having that greater clarity in terms of the visualization. And then we have enhancing the DEI Leadership Seal program by requiring a reporting component. And again, this is not at all punitive, but it's just a way for folks to communicate their success, their progress, and making these actions happen. And then also there's developing a continuum, which I went through the illustration of what that might look like. And then something new would be having a data collection tool on our website or somehow accessible, in which we're continuously collecting the best practices information that we can then use to inform future publications. Okay, so for next steps, I have an idea about future research, and that's thinking beyond just like issues in terms of DEI in the attorney workforce. So I suggest developing guidelines for attorneys to embrace equity principles in their work with informed members of the public. This idea, it comes from that Government Alliance on Race and Equity's work. They actually put together guidelines for government professionals about bringing equity considerations to the forefront of their work. And so I suggest potentially researching an opportunity for us to do that for attorneys as well. And then right now, I would like to invite your feedback, and also I would like to ask for 2 COAF members to form a COAF working group. And yes, so right now I would love your feedback, and if there's anything that was really interesting, I would love to know. And then also if there's something that didn't come up but that you're interested in, we would also love it if you would share that now with us as well. Thank you.
Thanks, Lauren. There's a lot of really interesting stuff in there. Okay, and new co-op people are also allowed to.
Shalak has a.
Oh, Shalak's got her hand up. The recording is muted over there, so I couldn't see Shalak, sorry.
Sorry. Lauren, I love this research. I think it's very, very interesting. I would love to be part of the working group. I also want to note that I think developing those equity principles, your idea around FAQs or guidelines could be really helpful. I have heard, again, from people in practice many, many years and shorter, that for people who are interested, committed to this idea of equity and so on, they are now at the barrier of, I've done some learning, now what next, right? Like, I have education, I've done the sort of like 101, what are the terms, do I use the pronouns, etc. But they're like, now how do I make this concrete? What are the things I can do and apply? So I would love to be part of that and developing that. And, you know, in my head, that becomes something that can also translate to pipeline work, right? So it's like members of the public, but also early pipeline, you're interested in going to law school and are committed to equity. You think you might want to be a lawyer and are committed to equity. You're in law school, you're committed to equity. You're, you know, whatever, wherever you are in your profession. So yes, please sign me up.
Great, great. Tristan, you have your hand up?
I do. I definitely would like to be involved in this. Unfortunately, I'm having to transition to the road. I've explained that I want to stick around. I thought we were only here for an hour, and so I didn't rearrange my day because I thought we weren't allowed to stay. But I definitely would like to be involved in this working group. So thank you very much for your work, Lauren. I think it's Lauren, right?
Yes. Yes. Great. Thank
Yeah,
you.
it's very exciting.
Okay, anybody else have questions for Lauren? Okay, seeing none, Judge, would you like to give the Judicial Council report, and then we will break for lunch, everyone, just so everyone knows where we are.
I would, thank you. And thank you for accommodating me. I managed to clear my morning calendar, but not so much for this afternoon. So I have 3 updates from the Judicial Council's Advisory Committee on providing access and fairness. The first has to do with our language access subcommittee updates. First is our signage and technology grant program, which is an ongoing program, and it is now in cycle 5. The goals of the language access signing and technology grant program are to support courts with the development of multilingual signage to help LEP users navigate the courthouse, to assist courts that may need equipment or software that will facilitate communication with LEP court users and the courts, to allocate funds to as many trial courts as possible within the given budget to support language access signage and technology initiatives, to fund enhancements that provide LEP court users with greater access to the courts and to information in their language, to encourage courts to establish grant funding, to apply for grant funding and an ongoing plan that coordinates with other facilities planning and or with planned or ongoing technology initiatives that support language access as a core service of the court. For cycle 5, this resulted in a proposed allocation of $423,567 for signage projects and approximately $1.9 million for technology projects, which will allocate the entire $2.35 million to a total of 17 courts. On June 15th of this year, the PAF committee did approve cycle 5 of the signage and technology grant allocation proposals. The associated grant report will be presented at the September Judicial Council meeting for final approval. The next update is with respect to the panel at the California Lawyers Association annual meeting, which is September 21st to 23rd of this year. The 2021 Judicial Diversity Summit partners, which are CLA, CJA, which is California Judges Association, and PAF, have partnered to host a panel titled Pathways to Justice, Increasing Judicial Diversity at CLA and CJA's annual meeting. The panel is scheduled to take place on day 2 of the annual meeting, which is Friday, September 22nd from 10:30 to 11:45 a.m. and this is in San Diego. The purpose of our panel is to educate, inform, and promote outreach to underrepresented communities on the judicial appointments and elections process. And the panel directly furthers one of our ongoing annual agenda products titled Diversity in the Bench. The speakers for the panel, it's quite a wonderful set of people. Moderators are the Honorable Victor Rodriguez, who's an Associate Justice of the Court of Appeal, First Appellate District, Division 3, and co-chair of our Advisory Committee on Providing Access and Fairness. Our panelists will include the Honorable Erica Yu, who is the president of the California Judges Association. She's also a judge of the Superior Court of California, County of Santa Clara. Also, Justin A. Palmer, who is the chair of the State Bar Jenny Commission, and Luis Cespedes, Judicial Appointments Secretary for the Office of the Governor. And my third update has to do with the Equal Access Fund distribution to the California Access to Justice Commission. On August 17th of this year, PAF approved 2 Equal Access Fund distributions to the California Access to Justice Commission, which was authorized by the State Budget Act of 2023. One was a $5 million, $5 million for grants to civil legal aid nonprofits, and then a $250,000 grant for administration of a tax advantage student loan repayment assistant program for service providers employed by qualified legal service projects and support centers. The report for grant distributions will be presented at the September Judicial Council meeting for final approval. And you can find the information on those meeting materials from August 17th at the California Court's website under the Access and Fairness Committee. So that's from my PAFA committee updates. I just wanted to say a couple personal words. This is upcoming September, and that's the time of year when all of our committees, and that includes with the Judicial Council and boards, welcome new members, and we say goodbye to our old members. And I wanted to extend my congratulations to Judge Kristen Rosie and Judge Michael Rhodes on their reappointment as chair and vice chair. Thank you to our outgoing members of COAF for all of the time and hard work and dedication that you've contributed to COAF, and welcome to the new incoming members who will join in December. I also wanted to make a note that I know the State Bar Board of Trustees will be welcoming a new chair for the 2023-2024 term, and that's Brandon Stallings. In case you weren't aware, Mr. Stallings is a deputy DA here in Kern County, where I sit as a judge in a felony trial courtroom. So Mr. Stallings appears in my courtroom on a regular basis. If you ever want a guest appearance from your chair of your State Bar Board of Trustees, I think I have a little in. I corralled him this morning and told him I was going to offer him up. So if I can ever offer that for you, I'd be glad to. With that, I'll see if anyone has any questions for me.
Judge, you remain our liaison, right? You're not leaving.
Yeah, no, that, yes. Yes.
Good.
I'll just add, and you probably know this, Judge Dulcich, but I'll be joining you on the Judicial Council Advisory Committee. So I'm really excited to see what it's like on the other side as well.
Exciting work, mirrors exactly what you all are doing.
Thank you. Pam, I see your hand. Do you have a question or?
Oh, you're muted.
Sorry. I'm Pam Enslin. I'm the Executive Director of Cal Law Pathways, and I was frantically trying to get my hand up earlier. I apologize, Judge, before you were speaking. I'd like to, assuming it's okay for a liaison, I would love to volunteer to be on the work group, the DEI work group, along with Shellac and Tristan.
In the past, liaisons have not been able to participate on the working group. They can participate as, experts and guests that the working group invites into the work. But in the past, the working group has just been mainly members.
Okay, thank you.
Definitely, we'll invite you into the process.
Thanks. Thanks, Pam. Any other questions for Judge Dulcich before we let her go? Okay, not seeing any. Pam, can I ask you, so we are running a little bit behind and we haven't done our break for lunch yet. Are you able to come back and do your liaison report a little bit after lunch?
Yeah, no problem.
Is that okay?
Yes.
Thank you. I really appreciate that. Pam, thank you. Okay, so we're gonna go on a break. It's going to be not a very long one. 12, we gotta be back by 12:30 because we have guests coming in for, so you can certainly have your cameras off when we, and eat while we're listening to the next update, okay? So everyone go get something and then come back.
Thank you.
So quickly, feel free to leave your cameras off if you're still eating lunch. I know I didn't give everyone a lot of time. So as you know, we moved item 6.2, which is the update on the future, the California bar exam, down to after lunch so that we could hear from some invited guests. Program Director Audrey Ching is here, and then Dean Jackie Gardina and Susan Boxian from the working group are here. So just to remind COAF members and our incoming COAF members who are here about, I'm gonna say 3 years, is that right, Audrey? Like 3 years ago that this whole thing started? So Ryan and I were appointed about 3 years ago by the California Supreme Court to serve as COAF's representatives to the Blue Ribbon Commission on the future of the California bar exam. As part of that work, the Blue Ribbon Commission, of which there were, I don't know, 20, 25 of us, something like that, were split in half. Some of us went to work on a bar exam sort of pathway committee, and some of us worked on an alternate pathway working group. Ryan was on the bar exam, I was on the alternate pathway working group. After 20 or more meetings and years and years and years of meeting virtually, the bar exam working group made recommendations to the entire Blue Ribbon Commission that California create its own bar exam. The alternative pathway working group was unable to reach an agreement, and when we got the whole Blue Ribbon Commission together, we were still unable to reach a decision on an alternate pathway. What I mean by that is that we voted about whether there should be one, and we couldn't come up with anything, and then we voted on whether there shouldn't be one, and we couldn't come up with anything. And so ultimately, after hearing all of the evidence and all the facts, and from people from all over the country and out of the country, we couldn't, as a commission, come to an agreement about an alternate pathway to bar admission. When the report that Audrey and her group spent probably every waking minute on for months, when that report was brought to the Board of Trustees, State Bar Board of Trustees, the Board of Trustees decided to create their own working group that was comprised of, I think, 5 members of the Blue Ribbon Commission. And they asked that working group to come up with an alternate pathway report and to make recommendations on an alternate pathway. For those who were at the meeting last time, you already heard me speak on this, and so I won't say much more about that. The new working group that was created has a draft report that COAF has been asked to respond to. And after talking with Elizabeth, I made the decision to invite some of those folks today to discuss what their report says. And I think, Audrey, I don't know if you want to start off before we turn it over to Susan or Jackie.
Yeah, really quickly. Thank you for that good overview, and also had me thinking, how long has it been? So it was October of 2020 when the Supreme Court adopted the charter for this joint Supreme Court State Bar Commission, the Blue Ribbon Commission on the future of the California bar exam. So it has been almost 3 years from that, but we started meeting in 2021. We met 19 times, both in the full Blue Ribbon Commission and in subcommittees. And then at the May Board of Trustees, the report that you referenced came to the May board meeting, and that is when the board directed for folks who were in support of an alternative pathway to test minimum competence to get together a proposal, and that proposal will be coming to the September 21st Board of Trustees meeting. Yet Jackie and Susan and that group have been meeting to develop the proposal. I believe it's the draft has been posted to this meeting, Elizabeth. Yes, yeah. So the draft has been posted. The State Bar staff has had an opportunity to read and make comments, and then the rest of the the Blue Ribbon Commission has disbanded in May when that was the end of the work. But the former members that were not on the working group have had the report and have been able to give their comments as well, that the working group is going to look at and make revisions to the final draft, the final report at the September meeting. I'm trying to think if there's anything else from what you said that I would need to add any color about, but I think that, just to tag on to your overview.
Thanks, Audrey. Jackie or Susan, to you, if you want to sort of give an overview, or would you prefer some other format about questioning? I mean, maybe you can start off by, I know it was the two of you and then Judge Reeser, I think Mylon Spencer from what used to be called Hastings, and I can't remember what my own law school is now called. And then there was somebody else on your committee, but I can't right now remember who that was.
Natalie Rodriguez from Southwest.
Right, okay, thank you. So maybe you can just start off by talking about what you all did, and then you can talk about the report if you'd like.
Sure. And we're here to answer any questions that you may have about the report that could help you better understand what it is we're proposing, and to answer any questions or concerns that you have about the current draft, which we have been receiving comments, so it has been adjusted and substantively looks pretty much the same, but some more material has been added. So first of all, I want to say that I'm speaking only for myself and not on behalf of the working group. So we can certainly speak to the contents of the report, but I think if we veer off into different topics that might be more opinion related, then I'm speaking for myself and not speaking for the working group in any way. Let me talk a little bit about process. The working group has no chair or any kind of hierarchy built into it. We did the report based on consensus. We've been meeting every Monday over the summer, and during those meetings, we've invited people in to speak with us. So we've spoken with 3 psychometricians, one of those being Dr. Henderson, who also served on CAPA and served on the BRC, and 2 other psychometricians to help us understand the underlying fairness, validity, and reliability issues that might arise in this kind of portfolio. We also had an opportunity to speak with Debbie Merritt and with Joan Howarth, both of whom are experts in the licensing field. And then we obviously had all of the BRC material that was presented to the subcommittee and available to the full BRC as well. I do want to make one slight correction to Judge Rossi's presentation of the BRC process, which is the subcommittee on an alternative pathway to licensure actually did make a recommendation to the BRC as a whole to pursue an alternative pathway to licensure, or at least explore one. The BRC as a whole was unable to come up with a consensus on that. There was no consensus on moving forward with it. There was no consensus on rejecting it. And there was no consensus on any other kind of delay or the like. So it just kind of never moved forward from the original proposal made by the subcommittee. So the proposal is, as I don't know how many of you have had the opportunity to read it, sets forth the underlying kind of premise, which is to have a portfolio-based examination that occurs in the context of a supervised practice of 700 to 1,000 hours. All of this is up for discussion by if the Supreme Court decides this is something they want to explore. There will obviously be additional work that needs to be done. And it's 700 to 1,000 hours of supervised practice, of which a portfolio will be created and independently examined, much like graders for the bar exam itself. And then we talked about some of the concerns that came up in the BRC in the report as well, and we're happy to go over those with you. And we talked to psychometricians about how to create a valid, reliable, and fair examination that has assessments that are psychometrically valid. And so we feel confident that we're going to be able to, or that the state bar will be able to create the kind of rubrics and assessments necessary to create that kind of validity. And Susan, anything you want to add to the broad overview?
I agree with the points that Jackie's made and want to reiterate, of course, for myself that, again, we don't speak for the entire working group. It was an informal process, and we are happy to answer your questions as two members who are very familiar with the contents of the draft and with the proposal. Just to add a couple of other things that your organization might find helpful by way of background, the details of the Blue Ribbon Commission and a summary of its meetings, its votes, and what it decided and how it proceeded is available publicly, because that commission is over. And I would encourage you, it might be helpful background reading for a lot of understanding the proposal that we're talking about today. And just to add to the overview, one additional point. The Board of Trustees did not create our group. They simply invited, they didn't actually invite us either. They asked for the people who supported a proposal to come forward. And I can't speak for others, but I myself volunteered immediately upon hearing the Board of Trustees' interest, but we are not an appointed or created group. We're a group of volunteers. And just to make sure that everybody has that list complete, it is myself, Jackie, Judge Reiser, Natalie Rodriguez, and Mylyn Spencer.
Okay.
Would you like us to start with questions, or would you like a summary of some sort?
Well, let me see if folks have questions straight away, and then if not, maybe you can just summarize it for folks, and then we can sort of talk about next steps.
So, yeah.
I'm sorry, Ryan, I couldn't see your hand, but now I can see it.
Sorry. Yeah, so I was on the commission, and I recall that there was a motion to move forward to recommend an exploration of an alternative pathway to the profession. And there was a vote, and that motion did not pass. That means the majority of the people who voted no. And so I'm a little confused when it's being represented that there was no consensus.
Oh, so that's directed to me, Ryan. Yeah, I think what I was speaking to is that there was no vote to reject it either. So there was no vote to move it forward, but when a motion was put forward to completely reject it, that was voted down as well. So the BRC couldn't come to an agreement about what they wanted to do with it at all. And so, and I'm happy to go back and provide COAF with all of the motions that were put before the BRC and the votes for each one, so they could see what the BRC did and did not vote for. But I don't want to get too caught up. I understand that the BRC didn't make a recommendation. The Board of Trustees obviously wanted to at least see a proposal. So is there anything that we can say or questions that we can answer about the proposal itself?
Yes, I have a question about the proposal. I was wondering what ideas you came up with to mitigate the concerns related to the folks in the Canadian example who reported experiencing harassment and discrimination when they're going through this articling process. That seemed to be the closest example of what we were working from as far as creating a California alternative. That was a concern of mine. And so I just wanted to hear about that. And also quality control. That's the second one.
Mm-hmm. Yeah, I think those are both great questions. So we do address directly the concerns that were raised by you and other members of the BRC based on what the articling survey showed. So the first thing that you can see is one of the things we did is when the PLL, the California-based provisional licensing lawyers, were surveyed, that kind of question was specifically asked about their experience within the PLL. And you can see from their experience, although a small n, it didn't dramatically impact their experience within the PLL, their ability to complete the PLL, nor did it differ dramatically from their experiences outside the PLL. So the other thing that we identified is if there is a problem with the supervisor, that the hours do not have to occur under the same supervisor, that people are able to move between supervisors. Another thing that we created with was, at least on a recommendation level, was an ombudsperson at the state bar level to help mitigate or manage those kinds of conflicts that might happen. The fourth thing that we did is it's not the supervisor that is assessing the person's work. It's independent examiners who are doing it anonymously. So there's not going to be control of the supervisor in terms of saying this work does or does not meet the standards. The supervisor does participate in the assessment in terms of identifying, and this gets to the quality control, identifying the person's work. So we can talk about that a little bit more, but before we move off, I want to point out one other thing that we found, I think, very attractive about the portfolio-based exam that I think goes to that fear about discrimination and also goes to your main mission, which is how to increase access to the legal profession, was the universal design. That it doesn't matter someone's abilities or disabilities, that this was going to be accessible to everyone at the same level playing field. Just like moving into the profession would be, they'll face the hurdles that you would in a professional work environment, but it's not going to face the hurdles of a standardized testing environment. And so the universal design of it was very important to us. The other thing it did in terms of increasing access was it reduces the cost to the individuals. So those who are working parents can continue to work because the supervised practice program allows for them to be paid. Instead of taking 8 to 10 weeks off, which many of them cannot do, to study for a bar exam during which they're not making any money. So it also really goes to the idea of making it accessible to low income or working adults who want to take the bar exam and enter the profession. So I think there was both things that we felt mitigated the concerns out of Ontario, as well as enhanced the fairness and accessibility of licensure here in California. And I'm gonna, before we get to control, I want to pass it to Susan to see whether or not she wants to add anything to that.
I agree. And what I would just add to Ryan's question is that Jackie's given lots of the specific reasons and details about how the portfolio bar examination would work. But I think it's also important to understand sort of the big picture or process of our working group was that while we considered Ontario and the other Canadian provinces as well, all of which have different approaches to how they license their lawyers, we ultimately did not adopt an articling method. And so much of our solution here has been to create a system that we based and modeled more closely after the provisional licensing that is actually in place and in operation currently in California, because that is more the realities of practice in California. And so that is a closer comparison than the articling system in Canada is. And we wanted to make sure that we would, one point of value is that we did get out of evaluating the Ontario system was that it was important that in creating a portfolio bar exam, we would need to create protections, and we've done so. And Jackie mentioned the highlights already. And so by creating those protections in the portfolio bar exam, we create a situation where we can have the advantages of the portfolio bar examination without some of the detriment that Ontario sees in their articling system.
Yeah. So I still feel like my concern still exists. I hear what you're saying, and I appreciate what you've said so far, but my concern is more philosophical when it comes to operating any business, especially a law firm, and the ability to attract and retain labor at the least expense. And also the power dynamic between someone in this provisional licensing program and an owner of a business who's using their labor for pennies on the dollar, as opposed to hiring a fully licensed attorney who can do the work in a market where attorneys are paid a lot more money because they can go out and get another job anywhere else. And I guess the rubric, the main framework is how is the state bar or anyone really going to attract, recruit, and monitor these supervisors? Who are these supervisors going to be? Is it going to be anyone? Do they have to pass the test? Do they have to get licensed? And then the second question is, how is this administratable by the state bar, who has a budget and fiscal concerns already with this current mission of protecting the public and addressing complaints?
I can go first. And again, we do talk about this in the report, specifically about the training of supervisors and specifically around implicit bias, as well as other kinds of training regarding feedback. I think there's two things. I would agree, we can't solve for all of that. I mean, there are flaws with the 2-day bar exam that we accept and move forward on. And there will be flaws with a portfolio-based exam because there's going to be no assessment that's perfect. So I think concerns about those are real, and they would need to be addressed in whatever we do with the pilot and beyond. But I think the other thing is that there are lots of supervisors who are interested in bringing on individuals, training them, knowing that or hoping that at the end of that training period, they're going to be able to move into a full-time position, rather than having the graduate and the supervisor wait until the bar exam comes through. So I think there's both, and I don't think it's one or the other. There's also a very strong interest in the public interest field for this kind of program to be available to them. So I think you're going to have supervisors, as there is in reality, that are difficult. And then there's going to be lots of upsides to it as well. So if you want to solve for all of it, I don't know that we'll be successful in doing that, but your concerns are warranted. And we haven't talked about quality control, and I can get into that next. But Susan, I don't know if you want to add to that.
I would just add a couple of things on the power dynamic. The power dynamic is alive and well in the legal profession, regardless of how new attorneys are licensed. And I suppose that in many ways that is part of this working group's mission, is to decrease those barriers and to work on solutions. But I do think that when we are looking at the power dynamic, what you do is build in the protections we've built in. And there are sections in the report that explain the ombudsman, explain the supervisor training, and explain that the supervisor will be a California lawyer. And there are already laws on the books in the Business and Professions Code that require all California lawyers to only put forth and forward those applicants to the state bar that they believe are qualified and competent. So the California attorneys supervising these individuals in the portfolio bar examination would be subject to discipline by the state bar. There are lots of existing protections, and I would agree with you, they are often not enough. And we do have societal and professional issues that we need to address. But the portfolio bar exam does a lot to remove barriers. And as Jackie mentioned, it removes barriers for working parents. It removes barriers for those who may have disabilities. It removes barriers for those who have lesser financial means. And by doing that, we can create a portfolio bar examination system where we would address those power dynamics by building in protections. Will they be perfect or 100% successful? No, but neither is anything we do to supervise lawyers in the practice of law and many other aspects. I do think that you've also asked lots of other questions about rubrics and about costs. And the costs are also part of the access issue. By removing the barriers a bit and by lowering them with a portfolio bar examination, we also significantly lower the cost to the applicants. The applicants no longer have to forego 10 weeks without any income. They no longer have to purchase an expensive bar review course and products, and they no longer have to have hotel travel. So these are costs that that the applicants would be able to avoid under the portfolio bar examination. Of course, any new examination or program would face some administrative costs. That is unavoidable in any alternative. But to go to your more general point is those costs would be incremental and not markedly different, and they are also outlined in the report, not markedly different from many of the costs the bar has on the two-day examination.
Okay, and after this period of trying out indentured servitude, being a provisionally licensed attorney, there's going to be an exam at the end, right? There's still going to be an exam?
A traditional bar
based exam, Ryan. So if you look at the report, it's portfolio based and it spells out the 7 to 10 items they must submit and have independently assessed by graders anonymously. So the portfolio is the exam.
Okay.
And it's not servitude. This will have a required minimum payment. That is our recommendation, that this be paid work.
Okay.
Shalak?
And you're muted.
Oh, geez.
There you go.
Sorry, hit the button too many times there. Thank you. I have 2 questions. I was able to skim. I won't pretend that I closely read the entire 114 pages that were attached to the document, the agenda, but I was able to skim, and I had a practical question, 2 practical questions. One that you might have just touched on, Susan, which earlier mentioned was the ability for those who might participate in this program to be paid. And then you just said, Susan, that you think there will be a requirement to be paid. Is there contemplation of creating a mandatory wage, a minimum that anyone employing in this would have to pay someone participating? Because, you know, I do have concerns about those types of inequities where people who may graduate from an ABA or otherwise law school, take a bar exam, are working as a post-bar law clerk, right, as we might call it, from kind of early August through November or so, being paid one rate, and those who, because of perceived differences in doing the written bar exam versus this proposed PBE, might be offered what's more generally a minimum wage, and the inequities that we see that fall pretty normally on people of color and women, which I would suspect are more the demographics that would take advantage of this other licensing pathway. And your report indicates the view that this would level some of those playing fields. I have concerns about perpetuating that inequity, right? Especially the variety of people who might participate. I can't speak fully, and Dean Gardina may be more able to, to the level of debt that those coming from California accredited schools might be graduating with, but I certainly have concerns for those coming from ABA accredited schools with an average of 120 plus $1,000 in loans. And then if they are also graduating and starting at a maybe federal minimum wage that's not in alignment with where their peers may be starting at, and which impacts their long-term ability to make more. So I'm going to pause with that question first and wonder, is that something that's contemplated? Was that part of this recommendation? If not, I would strongly urge on equity issues that it would be.
I think it's important to recognize that this is a draft and a recommendation to the Board of Trustees and to the California Supreme Court, who will ultimately decide how to craft the details. But it is our recommendation that the portfolio bar examination, that the supervised hours contain a minimum compensation. I did not say minimum wage, and if I did, I apologize, I misspoke. I did not mean the federal minimum wage. I meant a minimum compensation. And that, what that rate would be set at is one of the many details that would have to be established for the portfolio bar examination. But I think it's very important to make sure that we are comparing the correct things here. We're not comparing an ABA student who takes the bar exam and then receives a post-clerk, very high, frankly, sometimes attorney level wage. The comparison here is that right now, a student studies for the exam for 10 weeks and receives no wage. And they have to go without working and full-time study to properly prepare for the bar exam. And Access Lex and many other nonprofit organizations have done studies that have established the direct relationship between taking a bar review course, not working, and passing the California bar exam. So that does absolutely hurt people of limited financial means. It can disproportionately fall on women and people of color, parents, and other sort of non-traditional law students. And one of the things that we hope to guard against is to establish that we, instead of allowing the portfolio bar examination supervised hours to be without compensation, that our recommendation is that they will be subject to a minimum compensation. This is not what students would make after completing the portfolio bar examination, or what you've referred to as sort of the post-law exam law clerk wage. That actually is generally just a very short 1 to 2 month period of time where students sometimes make attorney wage prior to getting their exam results. But that is, we're not talking about that wage. We are talking about the wage to be paid during the supervised hours. And that would be set at a minimum compensation level. Currently, right now, law clerks work in all kinds of different wages, and some are closer, some are higher, some are lower.
I guess, sorry, just following up on that, I guess part of that for me was looking at the portion that says that, you know, there would be an assumption if the 700 to 1,000 hours were adopted, that this would take anywhere from 17 to 25 weeks, more realistically 20 to 29 weeks, which is more than that 8 to 10 unpaid that we're discussing. And that's why I started to draw that correlation.
Yes.
And that's
So,
where I have some of those concerns.
well, at this point, the choice right now for some folks is that they have to try to take the exam without properly preparing because they can't sacrifice the 8 to 10 weeks. So this would be an option, not a mandate. So students would be free to choose the exam if that was a better financial path for them. But right now, that path isn't available to a lot of students, and it is a barrier that students are not able to take a bar review course, to not work for 8 to 10 weeks. And how long they would take to do those 750 to 1,000 hours will obviously depend on what level those hours are set at, whether the Board of Trustees and the California Supreme Court wish, you know, how they establish the finer details of the program. Right now, we are simply establishing a recommendation and parameters. The decisions will need to be made later on the ultimate details. But I think it's important to recognize that options can be helpful when folks are facing no options at the right now. That right now your option is a 2-day traditional exam that requires you to go without work and to study full time for 8 to 10 weeks. And we would provide an option for those who prefer it to try the portfolio bar examination path with paid supervised hours, not unpaid. And that how long that went on would be determined by their hours and their flexibility. Again, it is universal designed to allow people the flexibility they need. Now, whether at the end of that 20, 25, however many weeks a student was paid as the supervised licensee, that person may or may not end up making more money than the person who forgoes the 10 weeks and tries to get a higher. An ABA student might be able to secure a high post clerk salary. But I'm not sure that that would necessarily, if that's only for the month of September and October, that would necessarily be preferred to constant employment without a break and to avoid having to not work at all.
And I apologize to Novella and Ryan. I did have one more that I hope will not be as lengthy and involved, and it goes to the finding of supervisors. And from what I gleaned in the recommendations, it appeared that the burden for finding and connecting supervisors that the state bar had perhaps contemplated, and maybe some conversations that are mentioned here, creating an initiative to connect people. And then that law schools may then take that on as well as part of their commitment to not admitting anyone that they don't believe would ultimately be admitted to the bar. Is that correct? Or do you believe, as I have a little bit of fear, that so much of that burden would shift to the applicant and create perhaps some undue stress? Which again, if we're comparing apples to apples, I will not pretend that the bar exam does not bring its own levels of stress, right? However, I'm curious as to the thoughts, and seeing that you're a colleague from Loyola, Dean Gardina is from one of the Cal accredited, right? So we've got some balance here as to sort of the realistic timelines for helping someone find that supervisor, making sure that they've met whatever competencies, that the person is adequately prepared from the side of legal education, so that we are, as the legal academy, fulfilling our responsibility to the next members of the profession.
Jackie, do you want to start on the supervisors?
Yeah, I can start, because I think you're right. One of the things is, and I've talked about this in the working group, is that there is an imbalance of resources between an ABA school and a Cal accredited law school. I think I want to take your last piece first, if I understood it correctly, which is about the law schools making sure that they're preparing the next generation of attorneys to be skilled, competent, and ethical attorneys. And for me, the portfolio-based exam actually allows law school curriculum to prepare people directly for the practice of law rather than exam taking skills. So I'll put that out there as well. I think two things. One is part of the survey for the PLLs showed that they didn't struggle in finding supervisors, or a small percentage did, although I think that varied. And I know I had some graduates who did struggle finding supervisors, and that we were able to ultimately connect them with alumni who were willing to take that on. So I think that concern is a real one, but the goal would be to have a more structured approach to supervisors. I can also say that we have received a lot of, both the BRC received feedback, and it's also been received by the working group regarding the public interest landscape being very interested and supporting this kind of work or this kind of pathway, in part because they could and are now working with people who are in the PLL pathway, and they see it as a wonderful way to potentially bridge that access to justice gap. I do want to bring one attention to the wage issue or the compensation issue, because I think that's another place where perhaps ABA and Cal accredited law schools are different. So the average age of my student is 40. They are working adults. Many of them have children and families. It simply is not possible for them to take 8 to 10 weeks off of work. It just can't happen. Maybe they can get 2 weeks off, but they certainly can't take 8 to 10 weeks off. And what we know from statistics is that if you can't take the time off of work, you're unlikely to pass the first time. So what those people are doing is continuing to work in their job, taking the bar exam at least twice, assuming that they weren't able to pass that first time, and extending the time before they get their licensure. And so for me, when you talk about kind of the inequities in terms of that higher paid law clerk job, that's not a reality for the Cal accredited law school grads for the most part. So while I completely understand the concerns that you have about the ABA, that on the Cal side, they're not going to be sacrificing that by deciding not to take the portfolio based and taking the exam, or taking the 2-day exam and not the portfolio based exam. Getting the license is what it's a dream delayed for them. It's what they've put on hold for so long. And so the idea that it might take longer rather than passing it on the first time isn't necessarily a reality for a lot of our graduates, in the same way it might be for the ABA. So I want to make sure that we're recognizing that some of the assumptions you're making about new law school graduates aren't necessarily true for California accredited law school graduates.
And I'll just add one quick point is they're decreasingly even true about large ABA schools like mine. I think sometimes there is an assumption that a very large and well-resourced school that is ABA approved has all graduates that are monolithic, or all graduates that are successful, or all graduates that receive very high paying offers, or that they don't struggle at all with the 10 weeks off work, with the exam studying period the way it is currently designed for the 2-day exam. Many of my first generation students and many of my evening students are far more like Jackie's students than people are assuming of a traditional ABA approved law school. And they do disproportionately become, those burdens can disproportionately fall on my students of color. And it is important, I think, to recognize that even at an ABA school where we think of people as being, where the school is well-resourced, my students are not. They are deeply riddled in debt, and they do need this alternative. Some of them need another way to access the bar exam, and a portfolio-based bar exam allows them that access without having to forego the 10 to 12 weeks of no income, and to recognize their other family obligations, their parenting obligations, and so much more. That today's graduates are a much more complex group than what we traditionally think of as that highly successful ABA graduate.
Understand that. I guess my concern around the wages was not just that immediate entry into the profession, which I completely agree. And I will say many people have images of what the Pepperdine law student is, and I and many others defy those images, right? And I work with those students daily. And part of their concern is not just, am I going to get licensed? It's when I look 3, 5, 7, 10 years down the road with what I will do when licensed, am I going to be facing these inequities for the rest of my career? Am I going to be starting in a position that's someone has managed to get me in a $62,000 a year, fake associate type feeling job, and I'm never going to be in the position to have the financial stability that I and my family thought we were sacrificing for. And so I'm not just thinking about that 10-week versus 29-week, but also wanting to assume the best about my colleagues in the law, but unfortunately recognizing that's not always true because it is a business, as Ryan said, that if I can hire someone at a slightly minimal level, get them through this PBE, make them this offer they think is amazing to stay on and tell them, oh my gosh, I'm gonna pay you $67,000, isn't that great? And every year I'm giving them a wage increase, it's never going to achieve. And I'm not even talking about the big law, $200,000 starting salaries. I'm talking about those even incremental things that data has shown us makes such a difference for immigrant or first generation or families that have been historically in poverty. The difference between being at $72,000 and $85,000, particularly in Southern California, can be wealth defining for generations of a family. And part of my concern is being sure, as much as we can in our flawed profession, that we're thinking about those immediate impacts as well as those long-standing impacts and how they will impact those older graduates or other non-traditional graduates that also go to our Cal accredited schools. I apologize, in a conference we would say that was more a comment than a question, and I took leave there, and so I apologize, and I'll turn over to my colleagues.
I would just suggest that a lot of, while I agree it is important, I think, to recognize that much of what you described there would be true if we had recommended an articling system. An articling system, I think, is fairly subject to the critique that a student may stay on and have a lower wage going forward, because that is a different kind of relationship than we envision here. The portfolio bar examination is actually designed to avoid some of that because it is designed to be a licensing process. This is not designed to be a permanent relationship. It may be that many people establish a permanent relationship and a job. And particularly, I think that would be true of our legal aid partners who have expressed a lot of support for this portfolio bar examination. They may very well intend to hope that those students will stay on once licensed and becoming lawyers. But I think it's important to recognize that the portfolio-based bar examination gives the student a license, and they are in no way indebted or obligated to stay and work for that offer if it is systemically too low, if it is unfair, if it is not the market wage for lawyers in that area. Then the lawyer has a license and is free to make another choice.
Novella, you've been very patient and you've had your hand up for a long time. Thank you.
Thank you. I guess I'll start with saying overall, I like the idea of a portfolio-based assessment as an additional option to try, as opposed to just sticking with the bar exam. It's what we've done, even though we all know it's broken in various ways. I take Shalot's point about the just the long-term economic implications of how the different licensing processes could affect different people, especially women and people of color. I think initially when I was thinking about it, it was more focused on the short-term time frame of like my personal experience, where it was like the option was like not having any pay while studying for the bar exam, while also taking out a loan just to like pay for my expenses during that time and also pay for like a bar exam prep course. And so I think in that respect, if you're just focusing on the short term, it doesn't seem, the portfolio seems preferable to me, at least, to the traditional bar exam. But I think I'm probably not the best person to weigh in on the long-term consequences, since I've mostly worked at nonprofits and government agencies. So I think it does, it could make a difference for how people's careers develop if maximizing their profit and their financial security for themselves and their families is like part of their aspirations in pursuing the law. I guess with the performative aspect of the portfolio, I do remember like having done portfolio-based assessments and taking classes about comparing different types of assessments and learning that like in a portfolio-based assessment, you can actually learn skills, whereas like I don't remember most of the things that I crammed for in preparation for the bar exam. So I think there is like a long-term advantage to doing a portfolio-based assessment if you're focusing on just the learning and skills. But that's all conditioned on like what the actual experience is for a person and like who their supervisor is. So I think it would be important, as Ryan said, to like explore when it gets to that detailed level stage, like what the supervisor vetting process would look like. With respect to the ombudsman suggestion, I think of that more in the context where like courts have those. And so because like the judges or whomever interact with so many members of the public, it's like less focused on a particular individual if someone were to go to the ombudsman. But I guess I worry that if it's in this context, that like a supervisor isn't going to have a ton of people who are licensing with them in this process. And so there might be ways in which like the power dynamic that's already part of the legal profession and has flaws could still pervade that. So I think it would be important to have like a number of checks in place to combat that. And I would hope that if we do end up, if this is passed, I would hope that like COAC would have an opportunity to like figure out what parts of this we can incorporate into our work plan so that the details don't get lost and like the concerns that folks are raising here, that we can try to be part of that solution.
Thanks, Novella. Ryan and then Sarah.
Yeah, so I mean, the more I think about it, the more concerns I have. Like, for example, and I'm just going to go through them one by one. So this assessment is more performative. It's based off of work created under the supervision of a licensed attorney. Before it gets to an assessor, I mean, can the licensed attorney ghostwrite the work to make it look better than it otherwise would have looked if it went straight from the person trying to get their license to the assessor? And how does that implicate attorney-client privilege? I mean, are clients going to have to sign a waiver saying essentially that the state bar can be privileged to attorney-client privilege material? I mean, how's that going to affect the ability of a law firm to derive a profit? And speaking of profit, you know, what happens if a program like this becomes expanded and operationalized? Because initially it's going to be a situation like we experienced with the provisional licensing program, where you guys leveraged your alumni network, right? This is going to be a hookup for people with connections, you know, and that's not necessarily going to help the people who have economic disadvantage or other types of disadvantages. It's going to have to be rolled out and expanded. And the only incentive for that to occur in a business capitalist environment is for people to decide to use this as an investment opportunity to save money on business, to save money on labor, you know. And I just don't see how someone who's involved in this type of program with economic interests is going to want to do something that's going to increase the labor liability, like keep the attorney on board after the attorney is licensed and pay them a higher salary. They're going to say, sorry, congratulations, next. You know, who's next? Who else can I bring on for the cheaper labor? How is that going to affect people, especially people with children? Like Shalak was mentioning, you know, it's a big Pyrrhic victory, I guess, because they're back on the street pounding the pavement looking for a job. Also, you know, we've mentioned multiple times this assumption that attorneys studying for the bar exam have to take 8 to 10 weeks off to study. Now, not every candidate for entry to the profession is created equal. And I know I'm not like everyone else here. I don't know what everyone's experience was like studying for the bar exam, but you know, I came from big law. I had the offer. I got they paid my bar exam fees, you know, and all that. I lucked out. And so I did not have to work. But when I was studying for the bar exam, the 3-day exam, it was so stressful, and I tried everything. But the only way for me to manage the stress was to actually go out and get a job selling laptop computers at Best Buy. That helped me manage my stress. And so to make the assumption that people can't work, I think I don't think we can make that leap for everyone, right? I know that the recommendation is that people not work, but I mean, for me, it helped me and my stress level to actually work a little bit. And so I just wanted to like highlight those points. And if you guys want to comment on that, you can. If you don't want to, that's fine.
I can speak to part of what you talked about. So in the report, we do talk about quality control, and we do talk about the attorney-client privilege and how all of that information needs to be stripped out of anything submitted to the portfolio. So that has been accounted for. Oregon is actually considering a supervised pathway program that their state bar has approved it. It's going to the Supreme Court next. They actually have a series of regulations already developed that address quality control concerns. So we wouldn't have to be starting from scratch in trying to figure that out. In fact, we might even have a little bit of information from Oregon in order to inform what would be the best practices for us. But their regulations actually speak directly to quality control concerns and how to address those. And so while, again, not perfect, there are regulations that have been written that do address some of the issues that you've raised.
And to address the issues of whether or not people work during the exam, again, in the report, we cite a variety of sources, but one of the most recent is the Access Lex study, which shows a direct relationship, a statistically significant relationship between working and failing the exam. So of course, there are always folks who defy the odds. And what we are trying to do with the portfolio bar exam is provide an option so that for the person who needs to work full time and cannot study full time, that they have an option to use a trained and vetted supervisor and be licensed under a supervised path with the portfolio items being evaluated by an independent, in an independent and anonymous way. And I do think that the provisional licensing program does show us that while some students certainly will have some issue with finding a supervisor, many did not. And there was no program at all when the PLL started. It was a COVID policy, and it was a situation of emergency. And when it began, we didn't have any way to really help people connect to supervisors, but we were able to do it. And I do think that the alumni groups will come forward. And I do believe that the alumni groups will come forward in much the way it is a natural expansion of current mentoring programs. If you have developed a close relationship in law school with an alumni mentor, it would not be surprising to me if that person was willing to take you on for the performance bar, sorry, for the portfolio bar exam, and have you work under them if you've developed a long relationship with them. So mentorship programs may naturally be able to expand to cover some of this.
Michael, and then Tristan.
So,
No, I asked.
okay. It's more of a process question, really, so that I have a better understanding of what we may be looking at going forward and when the opportunities for COAF's involvement or public comment would come along the way. This is an issue Novella raised that I agree with. So as I understand it, this is a proposal essentially that's going to go to the Board of Trustees. The Board of Trustees will consider it and then send it or something to the Supreme Court, and the Supreme Court would act on it either by approving, not approving, perhaps asking for another working group to consider additional details. We mentioned a lot of things that are going to require some additional details, including minimum compensation. So if I've got that all, if I don't have that right, please correct me. And if I do have it right, I'd appreciate knowing at what point various state bar organizations and the public will be able to be involved in the process of providing comments. And I'm glad that we have Leah here and we have somebody from the Board of Trustees as well, who might be able to add some to that as well.
I'll let Leah field it.
Yeah, I think it's a discussion certainly I've been having with my, I call him my counterpart at the Supreme Court. Some of you know Neil Gupta,
In terms of whether or not there should be formal public comment on the proposal, I believe he may have had a conversation with Dean Gardina as well on that. I'm not sure. And it's something that I need to discuss with board leadership. We had envisioned posting the report before the September board meeting, and obviously public comment is provided at and before board meetings in written and oral form, and many of you are familiar with that process. That's certainly what we had contemplated, and then if the board sort of approved doing so, we would send the proposal to the court after the September meeting. If there is a need or a desire to have a more formal public comment period, that would occur subsequent to the board meeting. The board would essentially issue the report and recommendations for public comment. And if that followed our traditional approach, then the public comment would come back to the board, presumably at its November meeting. And it is then that the board would make a decision as to what, if anything, to remit to the Supreme Court. So I'd say right now I have not had a chance to sort of vet all of this with the incoming board leadership. And I think it's a little bit in flux, but at a minimum, it will be posted in advance of the September meeting, and there will be all of those related public comment opportunities. And it seems as though there may also be a formal public comment period.
Thank you for that, Leah. And then I really appreciate the amount of work that's gone into this by folks on the Blue Ribbon Commission, by Susan, Jackie, and everybody else that's thought about it. But if the Board of Trustees says no, or the Supreme Court just says no, is there any other path forward for this, or are we back to considering just modifications to the bar exam?
I think if the board declines, the Supreme Court is always on its own motion, can do whatever it wants in this space. So I think that the board is not the final arbiter, but if the Supreme Court says no, then I don't see this advancing at this time. I mean, there is no other path forward that I'm aware of.
Can I ask a question, just piggybacking? I'm sorry, Tristan, I'm jumping in, but since we're talking about it, Leah, is the State Bar's plan to send the original BRC report plus this new working group report together, or is this work or is it just to send the new working group report up, or how is that? What's the, I guess, the plan for how those two things move together, or maybe only one moves? I don't know.
The board has already sent forward the BRC report to the Supreme Court. So that's there. They have not yet acted on it. And my understanding is the preference is to wait until this report is received and to act on it holistically. But yeah.
And the original one went up the way it was written by Audrey and her. Tristan.
Can you hear me?
Yes.
All right, thank you so much. Well, I'm brand new, obviously, so I haven't read any of the underlying documents, and so I want to be really careful with my comment. But I just wanted to say that as a newcomer in the space, I'm listening and I'm watching, and all of the people of color in this space are speaking against this proposal. And so I am very mindful of that. And if what we are trying to do is make the bar exam more equitable so that the attorneys in California can better represent the people of California, which we know is drastically lopsided right now, right? I mean, you all know the numbers. I would really worry that this proposal is not meeting that need. And so I'm glad that we're not voting. Obviously, I wouldn't be voting today because I'm not here yet, but officially, but I worry that we haven't come close to solving that problem yet. And so I just,
I'm happy to be able to sit here and listen, is what I guess what I wanted to share.
And I
Thanks,
think,
Christine.
and just in one comment to that, Tristan, I think the working group actually believes that this is a more comprehensive way to assess minimum competency. And that certainly the universal design is going to be beneficial to those who might not easily have access to the profession through the traditional bar exam. But we actually believe that this is equal to or better than a 2-day knowledge-based, memorization-based, standardized exam way to establish minimum competency. So it doesn't have just a one kind of reason for our enthusiasm behind it. And I've always spoken, and they heard me on the BRC, I feel like the bar exam tail wags the legal curriculum dog, and I am looking forward to, if the Supreme Court ultimately decides that this is a viable solution, to building a law school curriculum that speaks directly to the knowledge, skills, and abilities that new graduates need to have to enter the practice of law. And for those of you who teach in law schools, perhaps it's more in mind with the part-time program in California accredited, but there's a lot of focus on exam taking skills in a way that is, I think, disproportionate to the other skills that are necessary to be successful and to protect the public, quite honestly.
But Dean, is the underlying, it sounds like the underlying message here might be that our future attorneys of color are not capable of having the knowledge necessary to pass the bar exam, and that is fundamentally flawed. I mean, that can't be the underpinning of this work.
It's not the underpinning of this work, and if you and I encourage you to read the report.
Okay.
For the working group, and I hesitate to speak for everyone, so again, I'm going to keep to my promise to only speak for myself. This is about what I believe to be a viable alternative to a 2-day standardized exam for everyone. This isn't about any individual group, because I think it's going to better assess the knowledge, skills, and abilities that are necessary to protect the public. You can disagree with me, but I just have a very hard time understanding how a score of 1440 or 1390 gives someone the ability to hang out a shingle, because it's saying you could take that bar exam and then hang out a shingle and practice tax law, even though it's never been tested on the bar exam, because you've got that score. I'm not someone who believes that standardized exams are the be all and end all of establishing minimum competency. And I truly believe there may be other alternatives to look at as we think about developing the assessment of minimum competency to practice law. And I served on the California Attorney Practice Analysis Working Group. And one of the most striking things for me that came out of that was the idea that it took about till year 4 before somebody recognized the potential harm to a client. It went up dramatically after year 4. And this was in the ESM survey that was done. I encourage you to go back and look at that report. And what that said to me was, we have to make sure that new attorneys are getting the supervision that they need. But right now, what we're doing is saying, here's a score on an exam, go out and practice law in any way that you want to, regardless of whether or not you have a mentor or supervisor that is working with you. And what the supervised practice pathway and the portfolio exam pathway does, at least for me, guarantees a minimum amount of supervised hours that's going to be required before licensure, and also requires them to produce work product that better kind of speaks to what the practice of law is about in the context of the practice of law, and also requires them to demonstrate basic skills that are in reality what you do in the practice of law, such as negotiation, such as clients, working directly with clients. So while I understand there is a desire to kind of pin this on a one kind of approach, or that there's one reason to do this. For me, it is about public protection when I think of as a better way for us, or what could be a better way for us to actually identify minimal competency to practice law.
Thank you for that explanation, Dean. I really appreciate it.
And then Schlock.
Yes, I just kind of wanted to share like my deep-seated fear of a program like this, and it comes from an experience that I have, and a lot of people of diverse backgrounds have. There was once a time in my life before I was a lawyer where I worked for a very evil man, right? This guy, he held a very senior position in government. He was very visible. He very much appreciated firing people and would brag about it. I'm chop that person's head off. I'm gonna chop this person's head off. He spoke to me as if I wasn't even human. He made fun of me. He cracked jokes on the basis of my race. He did things to me that were demeaning in front of other people. Eventually, I reported him. There was an investigation that he sabotaged, but eventually he was found out because of my report, and he was removed from his position. I can only imagine what it would be like if I had $200,000 in debt and my entire career on the line, and I needed him to check a box saying I was good enough. Having to deal with that and endure those comments and the treatment just so I can get him to say that I'm good enough to the state bar or any organization. I mean, I don't even think I would have been able to survive a situation like that. And I say that to say this: not all lawyers, not all people are honorable people. And if we create a situation where there is such a huge power dynamic where these terrible people are in a position to hurt other people, to harass them, to discriminate against them for their own pleasure or whatever, they're going to do it. And I know you say you're designing these protections to be put in place, but you're also saying at the same time, like when the PLL program came out, there was a difficulty finding supervisors and assessors. I mean, we can't promise that the market is going to have enough people to supervise people who are engaging in this process to become attorneys, right? There's going to be a limited number. There's going to be a short supply, most likely. And I question who these assessors are going to be. Like, are they going to be like my former boss, or are they going to be like, I suspect, you ladies who are creating this program? Like, you clearly have great intentions. You clearly want to help people, right? Like, not everyone's like that. And if we're going to create this program where a lot of people are going to be hurt, which the reports coming out of Canada indicate, we should be wary about that. We should be very concerned. And there's other examples too. And I know you say this is not that, this is not an articling process, but I think the premise is that these people finished law school, they had to go through a process, and the supervisor had to say they were good enough to practice law. And I think that's the similarity here. And in Canada, you don't incur $200,000 in debt in law school. It's a lot cheaper. And so the power dynamic in California is a lot worse and disparate than the power dynamic in Canada. And so that's my concern, is people having to deal with the boss that I had and not having a way out and being trapped. That's my concern.
Thanks, Ryan. And I'm sorry that you had that circumstance. And I'll just reiterate again that it's not the supervisor who signs off. In fact, you don't have to stay with the same supervisor. It's anonymous graders assessing the portfolio submission, not the supervisor. So certainly you raise important concerns, but at least in the proposal, the supervisor is not the person who gets to decide whether or not someone can be licensed. It's that person's work product that is going to be the basis of whether or not they can be licensed.
And just to add one other point to respond to your concerns, I agree that I think too many people in our profession have worked in an environment like you described. Yours is certainly severe, that example. But I do think that one of the things we want to do is make sure that we use those kinds of concerns to build in the protections we need, not to say that we can't create a portfolio-based examination because one person might abuse it or a group of people might abuse it. Instead of, I believe we put the protections into it already. We hope to get comment like we've gotten today and from others to help us further refine the draft and the report to provide as many protections as possible against an abuse of power and against those power dynamics that no doubt exist in our profession and many others as well. And as much as I appreciate your characterization that Jackie and I and the others on the working group are here to help people, I would disagree a bit. I can only speak for myself, and as Jackie has said before, we each do that today. I would just add that I am an academic, I am a teacher, and there is a part of my job that is about helping people, but that is not what the portfolio bar exam is about. It isn't to help any group. It isn't to say that any group cannot take the exam and pass. Every group can take the exam and pass. That's true, but that does not mean that it is the best path to protect the public. It does not mean it is the best path to address the concerns in our profession. And I firmly believe that the work we've done, and I think all of us on the committee, one thing we do all have the working group, what we do have in common is a deep-seated belief in the draft and the report and the proposal we're putting forward, that we do believe it responds to concerns raised. It is not an articling program. It is not going to give supervisors that kind of authority. It's going to be a way to meet some of the barriers to access that are keeping people out of the profession that should not be kept out.
Shalak, and then Novella.
Thank you. I wanted to say to both Dean Gardina and Susan and Audrey that I deeply appreciate the heartfelt place that this is coming from. I agree with Dean Gardina that the bar exam as it currently is doesn't assess what I think we all know is necessary for practice. I think my concern is, which I know others on co-op have raised before, is in practicality creating a two-tiered system for who is viewed as being an appropriate attorney. I think that many other people of color have experienced questions about whether or not we are really lawyers or should be hired. I was a client walked into my office, saw me as the person and said, I do not want that Black person as my lawyer, and walked out. And thank God I had a boss, because this was my first job, who said, well, then we don't want you as a client, and fired the client. But more often than not, that's not the response, right? And if on top of that, there's any way, I mean, we can say all we want, you know, a licensed attorney is a licensed attorney, but if this is yet building on the inequities of our profession, we've already got the tiers that people may consider about ABA accredited versus Cal accredited, which again, we know does not really speak to whether or not someone can be a good attorney in practice. We've got ideas about within those schools, those tiered ranks of those schools, things Susan and I probably deal with pretty regularly when thinking about and speaking to students. We've got the implications of debt. And my concern is that even from a very well-meaning place, if we haven't thought through how those things interplay with the systemic inequities already available in our society, we'll be creating things where, again, more often than not, students of color, graduates of color will face yet another barrier to being seen as a full participant in our system and in our justice system and as attorneys. And contributing to that is something that concerns me. And I'm hopeful that when this is passed on to both the State Bar Board of Trustees and the California Supreme Court, that lens is considered, that the idea that now we are seeing lawsuits against many schools for considering various things about race in their admissions, in their involvement. And I cannot say that other attorneys would not bring those things to bear when considering whether or not they want to bring someone on for the PBE, or if a singular imposter syndrome or implicit bias training would be enough for these evaluators. I'm worried ultimately that we have something from a really good place that I would otherwise really support, because I agree, Dean Gardina and Susan, that measuring skills is what clients need, what the public needs. I'm worried again that without really considering how it interfaces with the real systemic inequities that exist in how our profession is administered, we are setting people who look like me and are first generation and immigrants and poor up for more problems than we are for solutions. And I hope that you all are really engaging with that when it's put forward. Thank you for indulging me.
We would look forward to your comments and help and guidance on anything you think that the working group should consider in terms of how it interfaces and how we might improve it.
And Shalak, and Shalak, you're right that Ryan and I both raised that during the BRC meetings, that a two-tiered system was a big concern for us. Novella, you had your hand up, and now you.
Yeah, I don't need to say anything.
Okay.
I'm good.
Okay, thanks, Novella. If you change your mind, let me know. Ryan.
Yeah, sorry, just the two-tier system. I know at least in big law, there's a practice of looking at the date that people finish law school on their resume, and then looking at the date they actually get licensed by the state bar. And the assumption, if there's a huge gap in time, that you fail the bar exam, right? And so, you know, I interviewed with a big law firm, and you know, there was a delay between when I was admitted to the bar, but I passed the bar exam on my first try. So I had to convince them, like, no, I didn't fail the bar exam. And then there was like an air of relief. Ooh, okay, good. We want to hire you now, you know? And so if there's this alternative pathway and there's a delay in time that suggests a student went through the alternative pathway, that's the assumption, they're gonna be judged on that, and they might not be desired, they might not be as desirable a candidate as someone who took the regular bar exam. And that's just the practical situation in the field of law, at least in big law, that I have observed at multiple big law firms.
Brian, I would just ask you to take a look at the report. It sets out the time frame for the portfolio bar examination. It's designed to line up to be similar to the receiving of results.
Okay, thanks.
Leah.
I was just gonna say on that point, I did see that in the draft report, but you could consider an even stronger recommendation for the state bar that if there are future changes in the timing for the grading of the bar exam, that there be an explicit effort to align the past dates for both pathways so that the situation Ryan described could not occur. And in addition, I'm not sure that I saw in the report a recommendation, which obviously we would implement, that we do not include anywhere on the public profile how you were licensed, the CBX or the portfolio-based pathway. I'm sure that's the assumption, but I don't think I saw it as like a recommendation to the bar.
Thank you, Leah. That is our assumption, that it would be non-differentiated. And also,
people are gonna ask, and I don't think that there's a reason. I mean, what's gonna stop anybody from asking? Did you take the bar exam, or did you do the alternate method? Nothing, right? I mean, I think you should assume people would ask.
the timing is, however, the situation Ryan proposes is not how it would operate under the proposal as currently drafted. The timing is set to line up.
So the way that, if I understand what you're saying, Susan, that the way an alternate path would work is that from that July to November, you take the exam in July, you get your results in November, that the portfolio time period is that same time period?
Well, it would start even earlier. The graduates would be able to start the day they graduate and begin their portfolio path.
May to November is the work experience that they would get under this plan?
Depending on what the ultimate amount of hours is selected and what amount of hours the person works, whether they want flexibility or not, they will have some choice in whether or not how fast they complete it. But those sorts of parameters in terms of the exact hours, exact timeframes for completion, what we have designed is set forward a proposal that has established sort of goalposts and ranges for ultimate consideration, but they line up currently with you could start the portfolio bar examination in May, the day after you graduate, and you could complete it theoretically even before others have bar results.
And I would say that's assuming that based on the assessment, the portfolio is successful. It could be that a portfolio is rejected and the person has to resubmit it just like they would have to retake the bar exam. So those are things that would need to be worked out through whatever pilot program or subsequent work that needs to be done. So the timing is aligned with the assumption that they're studying for the bar exam, the PBE people are working, they're taking the bar exam and waiting while the PBE are working and submitting their portfolio. They could get the results on their portfolio just like they could get the results of their bar exam, which may or may not be a positive result depending upon the work product.
I have to ask
yes.
a final process question. Thank you both again. My question is really for the chair and for Elizabeth in terms of how COAF can or might not be able to provide written comment to the Board of Trustees or the California Supreme Court going forward, given the timeline that we've heard.
Yeah, so Brian and I got the report, the draft report, which I understood wasn't public, and then had about 4 or 5 business days to turn it around. I actually asked Jackie directly if we could have more time because I wanted to get COAF's input. And I wanted to be able to have all of you here and be able to ask your own questions because for the last, 2.5, 3 years, you've heard it through Ryan and I, but I wanted you all to have a way of getting input. If we're going to respond in a way that is different than how we've responded right now, in this public meeting, then Ryan and I could certainly try and draft something really quickly, but I understand that, Jackie, when does the report have to go to the Board of Trustees?
So the working group will submit it to the state bar by August 30th so that it can get placed up on, do the agenda and be public in enough time. So our final report, whatever that might look like, will go to the state bar on August 30th. And then my understanding is you could certainly comment on it from there, as well as it sounds like Leah was talking about a potential for a post board comment period as well.
Yeah, and Leah, I guess it doesn't, so I guess, COAF could respond once it's posted to the state bar's agenda, unless there's going to be a formal public comment, and it doesn't sound like we quite know yet.
Yeah, we don't know. I was just thinking about this August 30th date. I want to circle back around with Audrey on that. It's nice in that it gives us plenty of time and we could post it well in advance of the board meeting. So kind of have an extended pre-meeting public comment period. But if there is a desire to make edits based on some of the feedback received in August 30th feels too aggressive, I just want to make sure we are giving as much flexibility as possible on both the front and the back end. But that being said, regardless, we always post the board agendas 10 days in advance of the meeting. That's statutorily required. So at a minimum, this would be posted 10 days in advance of the meeting, and we must have it before then in order to post it. I know that we are going to prepare a staff memo with our sort of reactions to the report, and so we need some time to do that as well. And I will have to confer with the incoming board leadership and the court about this public post-meeting public comment period.
So is there a way for COAF's comments today to be integrated in the draft report, or does it make more sense for COAF to file a public comment that's separate?
I think that COAF raised, or at least the people who had the opportunity to speak, raised really great points. If there's any way to formalize that through your process, that's great, and get it to the working group, we'd welcome that. And if it's not, I understand that timing for people is challenging, then certainly the comment period is the alternative. But I think important points were raised here, so we would welcome the opportunity to bring them back to the other members of the working group so that they could be considered as well.
And do you need those to be put in writing, Jackie, or can you do it based on?
Well, I certainly took a lot of notes. I'm not sure I captured everything, so I would be concerned that something got left out. And I don't know if Susan was able to capture it. I'm not sure how soon this will be posted as a public meeting available for others to listen to. So I think we would welcome something from you all to make sure that everything that was provided to us during this meeting was presented to the other members of the working group. But if not, certainly we could try to work off the notes that we took.
And we would appreciate, in addition to sort of the questions today, now that folks have had an opportunity to get more familiar with the portfolio bar exam, we would appreciate specific recommendations for improving it. So if you could add those to what you send along with your concerns, that would be very helpful.
Okay, thanks, Susan. Anybody else? Audrey, did you have anything you wanted to add in?
No, just thank you very much for all this great conversation.
Thank you all for coming and taking the time today to listen to all that COAF had to say. As you can see, we're not a shy group. So. Okay, and Michael and I, for COAF members, Michael and I will talk to Elizabeth about next steps and how we what we decide to do. Either try before August 30th, which is I think next Wednesday, or in a public comment. So Elizabeth and Michael and I will talk about it, and we'll get back to you guys.
Is Raul still on the line?
I don't.
Hi, Raul. If
Yes, hi.
submits a public comment, like a written public comment for this item to the board, do we need to delegate authority to the chair and the vice chair today to allow that to happen?
I'm sorry, can you repeat that one more time?
If there is to be written comment submitted to the board on behalf of COAF on this item, do we need to delegate authority to the chair and the vice chair today to allow that to happen? So that they can submit on behalf of the council?
I think the best course in this instance would be to do so, yeah.
Okay. So it sounds like we need a motion to delegate authority to our chair and vice chair to develop this written comment on behalf of COAF to submit to the board.
Okay.
I move to delegate authority to the chair and vice chair.
I second.
Anderson?
Yes.
Coleman?
Yes.
Harrison?
Yes.
Rhodes?
Yes.
Richards?
Yes.
Salceda? Santoro? Torres? Rosie?
Yes.
Okay, motion carries.
All right, thanks, everyone. So Michael and I will get together with Elizabeth and circle back with all of you. Thank you again, Susan and Jackie and Audrey, for coming today. Okay, so we're going to liaisons, or did I forget
Yes,
something?
liaisons, and then we can go back.
Okay.
Try.
Great, okay. So Pam, you've been super patient, and I really appreciate it. If you're still here and you'd like to do the California Leadership Access Workforce Report on Diversity and Inclusion Initiatives. Now is a great time.
Thank you. That was an important discussion. I appreciated being able to listen in. As I said, I'm the executive director of Cal Law, and I just wanted to tell you about a few things that we are doing right now. And first, I want to say that we put on an annual summit every year. COAF and the State Bar have been supporters for many years, including this past summit in February, and we're just so very, very grateful for that. Our next summit will be February 23rd and 24th at UC Davis. And we appreciate ongoing support. And if any of you would like to attend and want to just shoot me an email, I'll be happy to send you registration materials. We're also kind of apropos of some of the discussion today. We issued a statement following the Supreme Court's decision relative to affirmative action in admissions or in higher ed, and are having a program on Constitution Day for an hour and a half, a webinar discussing that topic. Your own Shellac will be there as one of the speakers, talking from the largely admission standpoint. We also have two other speakers, and the goal is to talk about what the decision did, what the decision didn't do, and more importantly, the doors that are left open for students to talk about the impact of their various diverse interests and characteristics, and how that should be considered in deciding whether to admit them to either an undergrad institution or to law school. We're also planning to follow that webinar up with another one about a month after that, again, talking about that same topic. And there is some discussion about having a third session, more of a kind of nuts and bolts for students and advisors on assisting students in finding ways to address their diversity in the application materials that they submit. So we're putting as strong a push as we can on this, because we want students to know there's still hope. There are still some ways to raise issues that the Supreme Court didn't close every door. We were just selected by the California Lawyers Association for its DEI Organizational Award, which is really wonderful, and we're very excited. We will receive the award at their, I believe they have a gala dinner on Saturday during their meeting in September in San Diego. And one of the other things we're working hard on right now, and appreciate any support we can get from any of you and others at the State Bar, is just getting more recognition of the name of Cal Law and what we do. There are a lot of people who know about us, and certainly educators, but what I'm finding as the executive director, I was a big firm lawyer for 30 years. I'm finding in California that many, if not most, lawyers and law firms really don't know who we are and what we do. And I think that we need to work really hard to change that. So any help you can give us, any ideas any of you have, any thoughts, please contact me. I'm happy to talk to anybody, anywhere, anytime, and go to any bar meetings you can think of to talk about Cal Law. I think that's it. Thank you so much. Appreciate
Thanks, and congratulations on a well-deserved
Thank
award.
you. We're very excited. Thank you.
For those who don't know, the COAF chair is given the honor of attending some of the Cal Law meetings, and so you get to hear about all the amazing work that's being done throughout the state.